Okay, we'll go on the record in People versus Eric Lewis. This is file number 255493. The record should reflect that Mr. Lewis is present here in the courtroom today. If I could have a counsel for the appearances on.
Sierra Koch on behalf of the people.
Thank you, Your Honor. Jason Thomas on behalf of the defendant, Eric Lewis.
Thank you. This is the date and time set for sentencing in this matter. Mr. Lewis, have you had an opportunity to go through the pre-sentence report and talk to Mr. Thompson about that?
Yes, I have, Your Honor.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
Your Honor, what I would say is when I allocute, Mr. Lewis has a lot of, or has things he wants the court to be aware of regarding the context of the PSI, the technical corrections or deletions, but we are going to be commenting extensively on the PSI for my allocution.
Okay. Are there any challenges to the scoring of the guidelines?
No challenges to scoring, Your Honor.
Ms. Koch, do the people have any additions, deletions, or corrections?
No,
Any challenges to the scoring?
no, I believe it's scored accurately.
Anything on behalf of the people for allocation?
Your Honor, I think the court is probably pretty familiar with Mr. Lewis's behavior through the PSI. Most things are documented. Honestly, he's 34 years old. This is, I think, his 9th and 10th felony. He's got 4 misdemeanors and a juvenile record. He's currently under sentence. He is literally his own worst enemy. You know, he can present normal and he can present appropriate, and then he can be completely out of control. I did read his thing from CMH that he has voluntarily went there 18 times and wants to continue those services. I think that's great for him. But if he doesn't learn some self-control, he's going to spend the rest of his life in prison. The guidelines are 7 to 28. He doesn't get any credit because of his current situation. I don't think he's earned the bottom end of the guidelines. I would ask the court to sentence him in the middle. Thank you.
First, if I could approach, Your Honor, Prosecutor Koch referred to it, but this is a letter from CMH that does describe his attendance and his willingness to participate in that CMH counseling he received here.
Okay, thank you. I've had a chance to review that here today. Anything else you wanted to say on behalf of Mr. Lewis?
Yeah, I had several things, Your Honor. Mr. Lewis wanted the court to know, you know, obviously looking at his record, the number of felonies, you know, there's only 4 adult felonies before here today. Mr. Lewis had an extensive juvenile record that led to him sort of unprecedented, in my experience, being sent to prison at 14. Really kind of a dramatic story when you read his PSI in terms of how long he had been incarcerated, what he got exposed to at a very young age in terms of adult, in terms of a prison. In his time, he did do a lot of additional programming that's referred to in the PSI, doing classes on advanced substance abuse, doing some classes on trying to get qualified as a janitor. As he had been out on parole here, he didn't have any formal violations. He did advocate to try to receive more services and benefits when he was here because he very much believes he needs additional help to become a functioning member of society. As he tells me a lot, he really has a lot of desires in that. He was making moves to achieve that. He wanted an apartment, he wanted to go to college, he was working towards enrolling in college, he wanted to have a productive life. Unfortunately, he had a very bad day here. It wasn't an aggressive thing, it was a non-compliance thing. He wasn't intoxicated that day, he zeroes it to jail. At some points, and I've watched hours of videos about this day, at points he does submit. He submitted handcuffing. He didn't attack officers, but there were points where he was not compliant. He advises me he was very sick that day. He'd been sick for a while, and that caused him to go off his medications. Couldn't bail it down. That caused him to go off his mental health medications, and so he wasn't in his best state that day. There are times when it's referred to that he was in a fighting stance. He really doesn't agree with that. And I've watched the video, and his hands were at his side. It's a very aggressive posture from his perspective. He's getting about ready to be tased, so he's tensing up. But he wants the courts to know he didn't raise his hands in an aggressive way. He had them at his side, but he was tensing up because he was about to get tased, and he ultimately was tased. Ultimately that day, he's the person who got hurt. He's the person who bore that burden on that day. He knows he really needs help. I think he's demonstrated a lot of insight into that. He knows he needs mental health counseling, and the court can see he's participated with CMH. He has a brother who's doing very well in Gaylord. He looks towards that in terms of a family member who has been able to do the things he wants to do. He did get a GED in 2007. He does suffer from mental health concerns. I think at some points it refers to his health as being in good health, but he wants the court to know he does suffer from PTSD, anxiety, depression, perhaps ODD. He was married and then divorced. In his background, I guess I wasn't clear about that. Mr. Lewis presents, as someone with a very difficult record. And I don't know that it's necessarily untrue that he is his own worst enemy, but he wants the court to consider a community sanction of jail time up to the 12 months. That would be appropriate, allow him to continue to try to work on the things he's trying to work on. Thank you.
Mr. Lewis, anything you wanted to say today?
Everything my lawyer has said is accurate. I do have like mental issues or whatever, and I understand this, like when I'm I guess faced with somebody that is talking aggressively towards me, I tend to match their energy because of the things I've been through and where I just came from. I did almost 10 years in a level 4 prison out of the almost 12 that I just did. So like, you got to understand, being a white guy and a smaller white guy in a level 4 prison does tend to, reflect on you because of how long it was, you know what I mean? And I don't mean to be like that. And I have been steadily trying to change this. And as you can see, like through everything I've actually did accomplish when I was out there, I was actually trying to do normal stuff. I wasn't doing drugs or nothing like that. I did smoke weed and I did occasionally drink, and my parole officer did know about this. And I'm not a liar, so I was always straightforward with him. And I took my medications, and like I told you the last time I was in here, when they came in, I was sick. I was real sick, and you can verify that through the jail stuff. Because I didn't eat for almost a week or something like that. I just kept puking. And like I was on like cough med, like all that, NyQuil, DayQuil, Courtroom stuff. You don't get that in prison. So like that was all new to me. You don't get any type of, narcotics, so to speak, like that. And then being off my meds, I was real highly emotional and stuff like that. You'll see in the video, if you watch the video, that I was sleeping. I was complying up to the whole time. And like I said, I don't even know why I said I ain't saying shit when they told me to send the chair. It didn't even make sense. At first, I thought it was just literally like a typo or something. And then when I seen the video, I'm like, damn, why did I say that? They don't, you know what I mean? Like, I'm complying up to this point. Why would I be like that? And then they try to force me into the chair. And I don't know. I wasn't in the right state of mind. I ended up apologizing to one of the cops, a younger guy, for it. And I told him, man, that's my bad. Like I'm trying to do right. I had a job out there. I was about to start college, and on November 4th, all I had to do was the FAFSA and just waiting on the time to file the FAFSA. But everything else was already in line. I was going to go for business and entrepreneurship. I was about to start an LLC and try to do like that resale stuff, to get a little bit of a side hustle going on. I was looking for a second job. I bought a bunch of stuff for the place I was living at, which is all gone now, but I bought a bunch of stuff. Like I was on the right track. You know what I mean? And like my next step was either to get my own place, which I was talking to Todd about, which was like the coordinator guy or whatever, and or get a car. You know what I mean? And another thing was like in 2023, I had a bad seizure that like left me like I flatlined all the way through, like they was about to pull the plug on me and everything. And they said, I'm a medical miracle that I should even be talking here today. And like, that messed up my mind a little bit, like, you know, thinking wise and stuff like that. And it's not an excuse, you know, this is documented through Sparrow Hospital. This is all stuff that can be checked into. And like, that's kind of why I'm on Capra and stuff like that, to help straighten myself out. I'm just trying to get, you know, a second chance, man. I'm trying to do the right thing. I don't want nothing to do with prison. I don't want nothing to do with getting in trouble. You know, I don't want nothing to do with none of that. Your Honor, I even, when I was out there, I called the cops a couple times, you know, just to show like I was trying to change. I even talked to John about a couple things that happened because I didn't know what to do. I've never called the cops on nobody before. So I was trying to actually be a productive member. You know what I mean? Like I you know, never done this, and I didn't really have any help. And everything that I was reading was I was supposed to get help. And then I didn't get no help. I got a place to stay. And then the first 3 days, the toilet didn't even flush, you know, and like, and I didn't, everything I bought was with my own will, you know, with my own doing. So, you know, and you can see like all the stuff that was in my apartment, like I got all that, you know, nobody else there in that phase motel had nowhere near as much stuff as I had. You can tell I wasn't doing drugs, you know, and I don't really know what else to say. Like I was trying. You know, it was just a bad day. I was sick. You know, I apologize to the court. I apologize to the cops mainly for even acting like that. Like, I feel stupid acting like that. I don't even like acting like that. Like, I play around, I joke and stuff like that. But, you know, but that's with like people that, you know, I'm comfortable with, you know, but other than that, dude, I don't talk to people like that. I talk to people with respect, you know, some type of intelligence. I don't like to do that. I've never came out of my bag with John that I can remember. I don't even think we've even had a bad conversation, you know, and I don't know. John's never done me wrong. I've never done him wrong. He's always been straightforward with me, and I've always been straightforward with him. Blame to the point, you know, like one point in time, I give you an example. At one point in time, I had like a little, it was kind of like a pocket knife thing or whatever. And I was using it to cut boxes up at my work, like cutting them open and stuff. Because I worked at Bears then, so I cut plastic open. It was real small. It was like the size of a razor blade. John said I'd get in trouble for it, so I ended up throwing it away just because I didn't want to get in trouble for it. You know what I mean? Like, I don't even have, anything that he said I'd get in trouble for, I just didn't do. You know, I was actually trying.
Okay, well, I did read through the report, so I'm familiar with the incident that brings you before the court here today. I read through the report that contains all the background information about you, your circumstances, your past history, your medical issues and so forth. So I have all that information. I take all of that into account along with what the lawyers had to say, and I listen very carefully to everything that you've had to say here. You know, first of all, I think make a really valid point that you have had a lot of negative experiences based on your prior incarceration. I think it's really understandable that somebody who's had to deal with what you've had to deal with, the way that you've had to live in prison, and the things that you've had to do to defend yourself and keep yourself safe and secure in that environment. You can't just switch that off when you're outside of it. And that, you know, when you're faced with certain situations, that background is going to tend to cause you to have, you know, an reaction and things that a normal person who hasn't been through those things wouldn't do. And so, you know, I think that's completely, again, understandable that you would react in that way. The problem is those officers don't necessarily know what your background is. They're responding to a situation, and they have to deal with somebody who's doing the kind of things that you were doing. And because you've had that background in your life doesn't necessarily give you the right to put them in a position.
No, it doesn't. I understand that.
So, and I say that because I think that's a mitigating factor, but it's not one that excuses your behavior in this case.
No.
And so that's one thing. I think what's positive is that you are taking steps through community mental health to address those things so that you can work on strategies to help you react in a different way than we did in this situation because of your background. And I think that's a big key for you going forward as to whether or not, you're going to spend more time on the outside or more time on the inside.
Yeah, I agree.
So I say that because I think that's something that I need to take into consideration. As you're aware, your guidelines are 7 to 28 months. I think your conduct in this case and your past history would certainly warrant at the high end of the I think the fact that you are addressing some of those issues and have voluntarily participated in community mental health gives the court reason to believe that there is potential for rehabilitation, and that it's something that you're self-directing as opposed to being ordered to do it, which I think makes a difference as well. And so in my mind, that moves the sentence from one that's at the top end of the guidelines to one that's more in the middle, because I think that sentence in the middle of the guidelines addresses the positive things that you're doing, but it also addresses the wrongfulness of your conduct in this case. So the court finds that the sentence of 18 months in the Michigan Department of Corrections to 3 years as each count is a reasonable and a fair sentence given all the circumstances in this case. Because of your parole status, you do have credit for 0 days served. Any sentence here is required to be consecutive to any parole violations. Court will order a crime victim assessment of $130, court costs of $25, $50, and $136 state costs. You have the ability to seek an appeal of the sentence. Appellate rights. Did you want this?
Yes, please. These are your forms if you want to file an appeal. There's 4 copies. You're going to initial the top one to indicate that you've received it. You're going to keep the bottom 2 if you want to file an appeal. One of the deadlines is 14 days. So you'd have to fill those out and turn them in within 14 days. Say the 7th, Your Honor.
It was email.
You can email it. Attach it.
I look for it.
All right, so you can keep those copies. You can fill those out if you will type them if you want to file that appeal.
Get that down. I'm going to have Mr. Clark remain right there. Got a microphone there that will pick up his voice. And I'm doing that for the safety of both counsel and Mr. Clark himself. So the court will call People versus Caleb Clark. We have 2 files, 255442, which is 5506. Record should reflect Mr. Clark is present here in the courtroom today. Mr. Clark, did you have an opportunity to go through the report?
Yes.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Ms. Koch, any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for help?
I'm actually really glad that Mr. Clark sat through the last sentencing, because I think that it's good for him to understand his history is really bad. He's had a pretty tough go of it throughout the last couple of years we've been dealing with him. And when he talks, he doesn't seem aggressive. And then you see these behaviors in the jail, and it's almost as if he doesn't want to get out of jail. It looks like he doesn't want to get out of jail. He just wants to stay in jail. And now he's moving on, and he's, 19 years old, and now he's looking at prison. And then, if he gets out of prison or he gets out of jail, whatever the court sentences him today, he's going to his guidelines are just going to keep going up and up and up. He doesn't have a lot of self-control in the jail. And for him to act the way he did in this case and put people in danger is completely inappropriate. And if he just wants to continue this path, he's just going to stay in institutions until he's completely institutionalized, which is really sad for a 19-year-old. So I hope that, this is the last time that we see Mr. Clark. I hope that the court sentences him within the guidelines. He doesn't have very much criminal history as an adult because he's only 19 years old. He's putting people in danger. If he can keep his head down and maybe get some help for his anger management and his behavior, maybe he can get on the right path. So I'd ask the court to follow the recommendation. Thank you.
Thank you, Your Honor. I do agree there's some sort of parallels to, unfortunately, Mr. Lewis being incarcerated for a long time and how Mr. Clark's adulthood is starting out. I really like Mr. Clark. He's 19. We have very positive interactions. I really enjoy talking to him. I really think he has a lot of potential. I think he has a lot of intelligence. I think he's pretty clearly on some sort of spectrum. He doesn't always express things the way a normal person does. And I think that's one of the really interesting and unique things about him. But that's what I see happening when he's losing control in the jail. He did advise and did confide in me that he had been assaulted while he was at the Wayne County Juvenile Facility. And that's part of why he has such he's capable of reacting so negatively when something bad happens, when he is incarcerated and things are not going well. It's really too bad that triggers, because he was on track to, be released here. More than any client probably I've had in recent memory, Mr. Clark is kind of on his own, working through foster care. He essentially had the state of Michigan as a guardian. Now into adulthood, he's going to have he has an adult guardian. And again, it's something from the state. He doesn't have family support. It's really too bad. He is in line. If and when he does get released, he's probably going to need to end up being in an AFC home. I talked to Caleb about boot camp. He's really excited about it. I think that is a really good alternative for him. I don't know that a 19-year-old doing long-term, months in the Crawford County Jail, I don't know that he's able to fulfill his potential in there. I think boot camp would be a really good chance for him to use some of that 19-year-old energy to try and grow and try and develop. So I really do think he's someone with a lot of potential, and I really do have high hopes for him, and I hope the court will sort of see him as that whole picture in terms of his background and what he's been through. Nobody's excusing what he did. It's really unfortunate that happened. I know Caleb feels bad about it, and I hope he takes the opportunity to apologize for it. Thank you.
Thank you, Mr. Clark. Was there anything you wanted to say today? The record should reflect Mr. Clark. I was shaking his head no. Mr. Clark, I did read through the pre-sentence report. You've been in front of me before on a different case, the probation case that we're going to talk about in a second. So I'm well familiar with your background and your history, and through that report, what happened in this case. And I agree with Mr. Thompson. It's really unfortunate. You haven't had much of a safety net in your life help you teach you the right way. And I think that, in addition to probably some mental issues that are something that are have developed over time, or you were just born with, have all combined, create a situation where you act out in ways that are out of control. It's unfortunate that we don't have a mechanism that can better deal with those kind of issues. Complicating factor is that you get violent. And so the number one priority for the court and the community is to have to make sure that everybody else is safe when you act out. That means, unfortunately, having some tighter controls on you, which I think contributes to the problem rather than solving it. But don't have any other good oh. Yeah, of course, the safety of others is a concern. So, 90% significant to yourself and to others, the way that you react to things. In terms of the recommendations here, I do think that they're appropriate. It sounds like you may be eligible for the boot camp program. If you are, that's something I certainly would consider for somebody at your age as an intervention. Maybe try to interrupt the cycle that you're in. And so that's something the court certainly would consider. You're a young man, and I'm not going to sentence you at the top end of the guidelines primarily for that purpose because of your age. They still have people for some rehabilitation here. But at the same time, I think there needs to be a significant penalty here. The guidelines in this case are up to 29 months, 2 months. One to 17, the other 14 to 29. So the court finds that a sentence of on the charge of the assault of behavior, the 14 to 29 charge, the court finds that an appropriate sentence would be 24 months to 5 years. As to the Arno charge, the court finds that an appropriate sentence would be 17 months to 2 years. I'm sorry, 16 months to 2 years. You have credit for 92 days served. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state cost doesn't count one. Doesn't count for a $68 state cost. You have the ability to seek an appeal of the sentence, and Mr. Thompson can provide those color rates.
You can initial it down for me. Walk down the bottom, bottom, 14 days. Fill that out, kite it out, and we'll start the appeal.
Thank you, that's all for this.
Your Honor, we have his probation violation up to, could we just discharge him unsuccessfully and dismiss the probation violation?
Address that, thank you.
Thank you, Your Honor. Prepare that order.
To appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You have a bond here. It looks like, right, Heather, of 4,010%, is that correct?
Yes, Judge. Yes.
We transferred one from another file, right?
Yes, that's where this bond came from.
So you have 360 to apply. Does he have the remaining 230?
There you go.
Okay, 360 now, that's your bond. That's in his name, right, Heather?
Let me double check that, Judge.
Your Honor, he could pay the 230 by tomorrow.
Okay.
Yes, it is, Judge.
Okay, so you can pay that by the 9th tomorrow, okay?
Yeah,
So-
he can do that online, correct?
Yes, and he's going to meet with probation just to set up a court work program. Best of luck. Keep
Thank you,
doing
Judge.
what you're doing. Thank you,
I
Mr.
appreciate
Gilbert.
it.
Thank you very much.
Thanks. You have a good day, and to you and your staff. and
You
Happy
too.
New Year, Judge.
Same to you. Drew Richard Dupre, 25F 245-129A, B and C. Your name? Good morning to you. Your name? You're charged with resisting or obstructing an officer, speeding and defective equipment. You have the right. No, you're not charged. Yes. I see defective equipment. Yes. 3 charges, 2 civil infractions. You have the right to an attorney. If you want one, I will give you one. You want a lawyer?
Yes, Chairman.
Why am I on there twice? Okay, you go out in the hallway. We're going to set you up with a lawyer. Either way, you're coming back in front of me, okay? Good luck to you. All right. Dylan Jeffrey Marzicki, 25R511 I'm sorry, 514428. Good morning, Mr. Fakaj. How are you?
Good, Judge. How are you? Happy New Year. Good to see you.
Same to you. Your appearance?
Yes, Roman Fitzai on behalf of Dylan Marlicki.
All right, so you're authorized to enter this plea. It's going to be a plea to impeding traffic, the speeding to be dismissed, true?
That's correct.
To that charge of impeding traffic, do you plead responsible on his behalf or not responsible?
Responsible.
All right. Yeah, he needs to slow down a little though, right? 175, I'll accept the plea. I'll give him a week, okay? So he has until the, let's see, the 15th, is it? Yep. Pay by January 15th.
All right, he will do so.
And he can go right on, 33court.com, and there's no fee if he's paying that all at the same time, okay?
Very good. All right, Judge.
Happy New
Thank
Year
you.
to you, counsel. Good
Take
luck.
care. Good
Thanks.
seeing you.
Tukari Sierra Moore, 25R 514404. And can I have Graham up here? Kira Graham, seated at the table, my right, your left. Ms. Moore, come on up to the podium and tell me your name, please.
Can I see the lawyer?
Okay, you're charged with reckless driving. You have the right to an attorney. If you want one, I will give you one. Do you want a lawyer? I'll arraign you and I'll explain the possible penalties and then I'll send you to the prosecutor if that's what you want. Okay. On November 27 of 25, it is alleged that you did operate a motor vehicle on Huron River Drive near Hazel in Rockwood recklessly. That is a misdemeanor punishable by up to 500 fines, 93 days jail. Costs of all of those 6 points in your license would be suspended. There'd be a hard suspension by the Secretary of State. For some reason, I can't remember if it's 90 or 120 days. Assume the worst. Do you understand that? All right. Did you sign the advice of rights? Did you read and understand the rights? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial of any kind. Do you understand that? Okay. Do you still wish to waive your right to a lawyer?
No.
I'll enter a not guilty plea, $500 personal bond. Do you work, ma'am?
I currently start work next week on Friday
Where?
at the whole station.
All right, I'll go ahead and appoint you a lawyer for this, John. She's going to need a lawyer too. And you go out in the hallway, tell the lawyer defendant was arraigned and defense attorney to pre-trial, okay?
Okay.
Good luck, ma'am. Either way, you're coming back in front of me. Kira Ann Graham. 25F245277. 25T644716. B 24T644312. 24F242667. Your name?
You're a grant.
Boy, ma'am, you got to show up in court. You know that?
I know.
Cannot do this. You've missed and missed and missed. All right, you posted a bond of 282 on 716B and 213 on 644312. Would that cover both of those, Heather?
On which ones were those on, Judge? I'm sorry.
That's okay. So we have 252 on file 25T644716B. Would that cover that case?
362 is the balance on that.
Okay. You in 213, will that cover the balance on the set 24T644312?
That is 248 balance on that one.
Will 309 cover the balance on 25T644716A? No, that's
344 is that balance.
Here's what I'm going to do. I'll give you a lawyer if you want. You posted the bond. I'll waive the balances on those 4 cases, okay? You got a 405 owed that you posted a bond on 24F242667. So I can get rid of those 4 cases if you want it. I'll send you to the Flat Rock prosecutor, or I'll give you a lawyer on the other drive while suspend. It's up to you.
I'm not sure which to do.
It's up to you. If you want a lawyer, I'll be glad to give you one. If you don't, I'm going to go ahead and arraign you. That is, explain the charge, the possible penalties and your rights on the new suspend.
Okay.
And then I'd send you to the prosecutor to talk.
I'll just go straight. Yeah, there's no-
So on December 7 of 25, it is alleged that you did operate a motor vehicle in the city of Flat Rock, County of Wayne, with a suspended license on Telegraph near Leonard at 2:33 in the morning. That is a misdemeanor punishable by up to 500 fines, 90 days jail, 93 days jail. Costs are all those. Do you understand that? And did you sign, read, and understand, John? I need those. I'm sorry. No, I got it. If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Okay.
You still wish to waive your right to a lawyer? Not guilty, please enter $500 personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. Now, I can get rid of these other ones right now for you. Mr. Kaylee, can you remember, are you out there?
He's in a breakout room, Judge. You want me to bring him out?
No, just. Yeah, would you please, and put him in front of me real quick? I just want to
Yeah.
explain. Ms. Graham, I hope you're going to learn a lesson today.
Absolutely.
Well, what are you doing? I mean, come on, how old are you?
Too old for this.
How old are you?
I'll be 40 this year.
Why would you do this to yourself? I don't understand. You're going to still have to pay any clearance fees involved. I want to be clear.
I was gonna ask, how do I take care of getting it cleared through the?
You're going to have to pay a $45 clearance fee. I believe just on, correct me, one case, because I'm going to waive any balances on the rest of these.
Thank you so much.
Heather, okay?
He should be coming in here in a minute, Judge. There he is.
Mr. Cayley, good morning. Your name? Happy New Year to you. Listen, I've got 5 cases here. She posted bonds on 4 of them. I'm going to waive the extra warrant fee. She's going to have to pay 1 clearance fee, but she has 1 new suspend charge. She's waived her right to a lawyer. I'm sending you this one. I'm going to keep the other 4. She's going to end up having to pay those. She's been absconding for a while here. These were from August of 24.
So the other 4 have been adjudicated?
Correct. She's posted bonds.
Okay.
And she might be $35 short on this one and that one, but I'm going to waive those. So I'm just going to give you the 1 Flat Rock case, but I wanted you to be aware if you want to cut her a bigger break. John, can you hand it to him? That I'm going to keep these other 4, and she's paid about somewhere in the neighborhood of $213, $482. So that's $495, $795, $804, $1204, $1209. She's paid on these other 4.
Clear for driver's license?
Yes. Well, I don't know. I didn't look close enough.
Okay.
She's going to have to pay 1 clearance fee. I'm going to make her pay on the 1 no proof insurance. I'll just have them give you all of those. Just send them all back. Okay. I just wanted you to be aware of what's going on. You go with him. I mean, I don't know if he can get you in now, but
Okay.
Just have a seat, Holland.
Okay.
Heather, 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal.
I was in the straight.
It up. Audrey Ann Cousineau, 25F245-225. Good morning. 59A attorney. If you would like an attorney, do you think we can have somebody staple those?
Yeah, it's me. I'm not,
All
I'm
right,
trying. I'm doing my best.
fine. Daniel Joseph Conway, 25F245-159A. Which one do you have there, Mr. I don't have your file in B. So if you want to go scrounge it up, I'll call you, Mr. Osmond. I don't have it. Which one?
Who's in Audrey?
Your name, sir?
Daniel Joseph Conway.
You're charged with driving on a suspended. You're also charged with false information. You have the right to an attorney. If you would like an attorney, I'll be happy to provide you with one at public expense right now. Would you like a lawyer?
Yes, sir.
Okay. So we're going to take you go sit out in the hallway. Mr. Cayley, I'm going to send in this Conway case, and that will be with Flat Rock, but he wants an attorney. I know. He wants an attorney, so we'll give him an attorney. I don't know if maybe you can help expedite that, Roger. He's running around here. What's that?
Judge, you should have Mr. Osmond's file.
I know, they just put it up. Audrey Ann Cousineau, 25F245225. Good morning.
Good morning, Your Honor. Jeff Osmond on behalf of Audrey, please know.
Ma'am, your name?
Audrey Crusoe?
She's charged with operating while intoxicated. What do you have here? I mean, first of all, does she stand mute? Wait for me.
Wait for reading for the purpose of knowing the plea with word.
Okay, I'll enter a not guilty plea, and now she's going to plead guilty to operating while impaired with the OWI to be dismissed, correct? Is that what you want to do, ma'am?
Yes.
If you plead guilty here, the possible penalties are up to 300 fine. I'm sorry, up to 300 fines, 93 days jail, 360 hours community service. Court costs are all of those. 4 points would be added to your traffic record, and your license would be suspended or revoked in accordance with your traffic record. Do you understand that?
Yes, I understand.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, I understand.
Do you have any questions before we go on?
No.
For the charge operating while visibly impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on November 23 of 25 at 1:55 in the morning on Telegraph near Eastern River Drive in Flat Rock?
Yes.
Did you consume alcohol at that time? And if so, what did you consume and how much?
Yes, I got a blood test. It was 0.15.
0.159?
Yeah.
And do you stipulate that that was an accurate reading for purposes of the plea?
Yes.
Are you on probation or parole?
No,
How much did you drink that night, ma'am?
I had 5 drinks that night.
What kind of drinks?
2 seltzers, a mixed drink, and 2 beers.
Why were you pulled over by the police?
I was in Poplar Lane.
What do you mean by that?
I was in the straight lane instead of the left turn.
She made a left turn from the wrong lane.
I see. Anybody force you to plead guilty here?
No.
You still wish to plead guilty?
Yes.
All right, I'm going to accept your guilty plea. I find it to be an accurate plea made voluntarily and understandingly. That plea is accepted. I'm going to go ahead and dismiss the OWI. I'm going to give you a personal bond of $1,000. I do want you going to AANA at least one time a week. She's 21, right?
Yes.
Okay, so you're young to be here, and that concerns me, right? You have twice the legal limit. So I'm going to go ahead in order that you not leave the state without the consent of the court, that you cannot violate a law. You must appear in court as directed, AANA once a week. He's going to hand you a form, no marijuana, no alcohol, no illegal drugs. Do you understand all that?
Yes, I understand.
All right. And also no contact with prosecution witnesses. We'll give you a copy of this bond sheet. We'll give you a copy of your notice, and then you're going over to be screened and assessed. Do you have a date for me, Heather?
Yes, February 5th at 9:15.
With you?
February 5th at 9. Judge, I'm going to be gone February 5th through the 8th.
Good for you. All right, let's, I don't really even need to do this on a flat rock. There was no accident, right?
No, there's nothing.
I don't need to do this even on a flat rock day, Heather. We could do this on a Monday if you want, the following week, but he's not available on the 5th. If you want to do it on the,
What were the dates that he's out of town?
5th through the 8th.
right.
February.
Do you want to do the 4th? Does that work?
That would work.
Okay, we'll do the 4th.
Let me
Yeah.
take a look at a time for the 4th real quick here.
He's retained. How about we try 8:30? Is that good?
We could do
Fine.
8:30 if he's
Perfect.
available. Okay.
8:30. Okay, good luck. Be careful. Okay, thank you.
Probation.
Yes. Yes, and she can first go down and get her notice and then back over to probation. And they'll give her a condition of the bond sheet too.
Okay.
Thank you.
Thank you.
Thank
Have a
you.
good day. Good luck.
Thank you.
People against. Caled Holly, 25R 514-447.
No.
Good morning, sir. Your name? Okay, just keep your voice up nice and loud. You are going to plead responsible to impeding traffic, right?
Yes, sir.
To that charge, responsible or not responsible? Okay, I'm gonna accept your plea of responsibility to that charge. I'm gonna set fines and costs in the amount of $150, okay? You can go down the hall and pay that and you're all set.
Thank you, sir.
Good luck. Jacob Martin, file 25R5-14450. Good morning. Your name?
Jacob Martin.
All right, so you're gonna plead to impeding, right?
Yes, sir.
Responsible or not responsible to the father. Plea is accepted. 150 is your total. You can go down the hall. Hang on 1 second, please. Oh, no, I can't charge just 150. You've got some entries here. $175, okay?
Yes, sir.
You can go down the hall and pay that and you're all set. Good luck.
Thank
Happy New Year.
you.
How you doing, Mr. Daly?
Well,
Good.
this is curious. In 4 cases.
Oh, okay, okay. Come on up here, ma'am. People against Kira Graham, Kira Ann Graham, 25F-245-877. All right, how are you?
Good.
Your name?
Kara Graham.
You met with the prosecutor. You're going to plead guilty, this says, to allowing an unlicensed driver to drive, right?
Correct.
That's 0 points. It won't go on your record. If you plead to that, I'm going to dismiss the suspend charge. The possible penalties on this are up to 500 fines, 90 days jail, costs, or all of those penalties. Do you understand that?
Yes, I do.
And did you sign, read, and understand the advice and rights form here
Yes, I
today?
do.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. Do you understand me?
Yes, I do.
You still wish to waive your right to a lawyer?
Yes.
The charge, allowing unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a motor vehicle that was being operated on Telegraph near Leonard and Flat Rock, December 7 of 25?
Yes.
And were you operating that vehicle?
Yes.
And your license was suspended at the time, and you knew that. Is that true?
No.
It's still suspended, right?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
Yes.
Please accept it to that charge. I'll sentence you, and I'm dismissing the suspend pursuant to the agreement. Give me 1 second, okay? Where do you work at?
I work at a place called Flex Services. I do clerical work for a small business.
This is a third-party poster. Who's the third-party poster?
My mother.
Is your mother here?
No.
She gonna let you apply the bond?
Yes.
You better call there. Go down the hall,
Okay.
get your phone.
I have it.
Okay, just go right out in the hall, call your mom, and I'm gonna have her call you, Heather, right? Or should I have her call the cashier?
Cashier. Her extension is 212.
So listen, it's 734. Here, I'm gonna write it down for you.
Thank you.
Here, Sadie, can you at your please? You come on up there and get that.
Thank you.
And then if she can call, then they'll tell me, then I'll send you on this, okay? Fair enough?
Yes.
All right, good luck.
Thank you.
People against. Ramirez Vasquez. 25F 10140. I'm not sure what ring, oh. See,
You should be translated.
okay. Can I see the docket a second? Can you hand me a copy of the docket? Okay, John, come here 1 second, please. So they pull his name up. See, Heather, can I ask a question?
Yes, Judge.
This Ramirez Vasquez, he needs a Spanish interpreter. It's just here for a review hearing. The problem is it's impossible for us to tell when somebody puts it down as a show cause. This is not a show cause today. I've never paid attention before, frankly, but shouldn't it be down as a review hearing or something? Because then at least my court officer's going to know to give it to the prosecutor. And then the defendant's not going to have wait in court and have me tell him it has to go to the prosecutor.
Yes,
I'm going to talk to you about that later. But Mr. Cayley, it's just you. He doesn't speak English.
Does it say he's compliant?
They didn't write, they just wrote balance 0 because I didn't order anything else. I want to convey, I hate to bring in an interpreter just to convey to him I'm dismissing the case. Is there a way we can do that? Anyway, don't we have that little translator with advice of rights, or is it just with advice of rights?
As far as in
I don't know how to
Spanish,
tell the guy I want to dismiss his case. I don't have to hire an interpreter.
we up here just use Google Translate on our phone when we speak to them in Spanish. I have it on my phone. I don't know if anyone in the courtroom has it on their phone.
We're going to have to figure that out. Jeez. You got any ideas? I'm going to dismiss your case.
Judge, you want me to come down real quick with my phone? Or do you want to send him down here and I can tell him on my phone?
I'll send him down. Can you understand it all? No, you can't.
Do you want me to run down real quick, Judge?
Yeah.
I'll come down with my phone real quick. Okay, I'll come down.
So you're moving to dismiss, right?
Yes.
He paid his money. He's done everything else. So dismiss motion of the prosecutor. Wait 1 second.
Yeah, just.
Nice.
Hello.
That's better than I can. I can do Ola K Tal. That's all I remember from high school.
Got to coach on a supplement.
Sure. We're on YouTube.
Oh. Let me go off.
Yeah.
Yeah.
Have your best shot, because I'm ready to go. Mr. Cook.
People would waive any potential conflict between this honorable court and the office of the public defender. While the people do not believe that any conflict exists, we make this waiver and the avoidance called out.
All right, thank you.
Mike Getty, Public Defender's Office, Your Honor. Likewise, Public Defender does not believe that there's any conflict with us representing people of this honorable court, and we would waive any conflict. We'd ask the court to waive any conflict if there is one.
Court for its part also does not believe there's a conflict. Neither did Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Diamond Rivers, or Byers, excuse me.
Morning, agreement to the people.
Okay, this is a good start.
I'm sorry, I didn't hear you.
I do feel lucky.
What?
I feel lucky. I didn't hear the name though.
She's right behind you. Your client, Diamond Byers.
Edward.
Hello, Ms. Byers. You guys
Diamond
need to
Byers.
switch sides. This is not
Okay.
starting well.
Oh, my gosh. Hello.
Good morning, Your Honor. I'm asking for an adjournment today. I got appointed to the 2 new matters and I'm waiting for some discovery.
Your name, ma'am?
Diamond Byers.
All right, thank you. All right. We were trying to, never mind, she's talking to Kilovolt. Daisy. Probable cause conference will be adjourned to January 29th, 2026, 9 a.m. Bond in these matters will continue.
Thank you, Your Honor.
Thank you. Thank you, Ms. Barr. Court does call the case of the people versus Michelle Campbell.
Morning, Honor.
Brian Bowling on behalf of Ms. Campbell, Your Honor. State your name for the record.
Michelle Campbell.
All right. Judge, we do have a resolution which will require a no contest plea.
Just gotta get the paperwork.
Yes,
in.
please. So if I could get a week if possible.
Probable cause conference, January 15th, 2026, 9 a.m. Bond.
Thank you, Your Honor.
All right. How you doing, Ms. Campbell?
I'm doing well. How about yourself?
Not too bad. I get to
That's
see you
good.
next week, right?
Yes.
All right.
You definitely will.
All right. Thank you, man.
And I'll
Have a
see you.
blessed day.
Thank you. Court calls the case, people versus Bobby Tennyson. There's a. Yeah, that one's gone. Court calls the case of the people versus Gary Coward.
Bring on may please honorable court David Burgess on behalf of Gary Coward. Who's approaching, Your Honor?
Your name?
Gary Coward.
Thank you. You're seeking an adjournment?
Correct, Your Honor. Couple of weeks will be fine, just so Mr. Chavalowski can get caught up and potentially resolve it at the district court level. Thank you, Your Honor.
January 29, 2026, 9 a.m. Bond continue.
Thank you.
Court calls the case, people versus Joshua Wara.
Andrew Jones, hearing on behalf.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Wara. Mr. Wara, will you state your name for the record?
My name's Joshua Wara. It smells like blunt smoke and cologne in here or something like that. Sorry about that, Mr. Simpson.
It's okay.
You doing all right?
Me?
Yeah.
I'm great. How about yourself?
Nice to see you today, man.
Good to see you. All right.
Your Honor, our office is in receipt of a report dated December 10th, finding that Mr. Wara is incompetent but is restorable. I did prepare an order. We would stipulate to the finding of that report.
What's that mean?
Anything from the people?
And there's some bullshit.
Oh, Mr. Wara? We talked about that before. We don't use that language, right?
Yeah, I'm sorry, Your Honor. I just don't agree with having to go.
No, I understand that. Just don't use that language. You may not agree with it, but that's what I've got in front of me, okay?
All right.
All right?
All right. Sorry about that, Your Honor.
It's all right. What I will do, given that that's the information at this time, and your attorney will explain everything to you, okay? So don't get upset by it. I'm gonna, all I have.
You think I need the forensic center? I got a Neuralink attached to my brain that's causing the schizophrenia. It's a telepathic communication device that also uses visionary hallucinations, which means the person I'm connected to can see everything I'm seeing, but I have no glasses, so it's just a blur to them.
Got it. Okay, so you make sure to explain that to all of the people that are gonna see you now.
What, at the forensic center?
Yeah, at the forensic center, and then there may be other people that.
How many days am I getting in there?
Well, I don't know yet, but what I'm gonna do is I'm gonna find that you're incompetent at this time, okay? And then, Laura, remember.
Sorry, Your Honor.
Okay. I'm gonna do that, and then I'm gonna set a review hearing so that you'll be able to come back to me at 90, please.
All right.
90.
April 2nd at 9 a.m.
All right, so I'm gonna set a review hearing for April 2nd, 2026, 9 a.m. So you'll get to come back and see me.
All right.
And
I saw
let me
you on
know what
court
all
cams,
those people
dude.
said, huh?
I saw you on court cams, dude.
Did you?
Yeah, I saw you on court cams.
Did I look good?
Yeah, you was looking beautiful. How about?
All right, thank you. All right, take care. I told you, Alan, I have friends. Court calls the case to be people versus Raisha Anderson.
People.
Morning, Your Honor. Please, this honorable court, Brandon Bird on behalf of Bryce Anderson.
And Assistant Public Defender Chelsea Ridgefield with and on behalf of Bryce Anderson on other case timeline 5640.
I'm on 5330, Your Honor.
I know. And you were pushing mystery fields out of the way. Your name, ma'am?
Bryce Anderson.
All right. You are both requesting an adjournment or what are we?
Yes, Your Honor.
All right. I don't have her green sheet. Probable cause conference in these matters will be adjourned January 29, 2026, 9 a.m. Bond in these matters will continue.
Permission to speak, Your Honor.
Pardon?
Permission to speak.
You already are. Go ahead.
Respectfully, my client missed her court date yesterday. She showed up late. She indicated that she did put in a warrant recall, and we're just trying to see if we can get that warrant recall.
This is a case from yesterday?
From yesterday.
Okay, so of those 109, I'm supposed to remember. I don't, so what are you asking?
It was a case from yesterday in which I had Miss Anderson actually had a case in which I represented her, Your Honor. I'm asking, can we recall the warrant from yesterday because she didn't show up? Or she showed up late.
But she wasn't here yesterday.
Correct.
That's what you're telling me.
Correct.
And now you want me to do something about a case that I don't have the file for from yesterday?
Correct.
And if I say no, what happens?
I'll say, can you please reconsider, Your Honor?
What hasn't?
The online recall that she did.
So she already did the online recall, but you haven't received an answer from us, right?
Correct.
So what will happen is it hasn't gotten to me yet, or my staff yet. So it should be taken care of.
All right, thank you, Your Honor.
You're welcome.
Appreciate it.
I always appreciate you too.
I'll
Take
see you
care.
this afternoon.
Okay, that's a threat. Court calls the case, People versus Devontae Connor Belcher.
Geraldine Foster Tucker on behalf of Devontae Belcher. Can you state your name?
Devontae Connor Belcher.
You're seeking an adjournment?
Yes, Your Honor.
Appointed on this. Probable cause conference, January 22nd, 26, excuse me, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Tanisha at Aikens.
Morning, Your Honor. Raymond Cook with People.
This is we're gonna Apple on behalf of Aiken who appeared on the.
Waiver.
I apologize. Looks like she went to the restroom.
Or warrant her, one of the two. Court calls the case, People versus DJ Dan DeMoody.
Now an assistant prosecuting attorney on behalf of the people. Oh, no, wrong. Sorry, wrong one.
What?
No, it's not my case.
It's not your case?
Mr. Hauser, and then I have to be later. Mr. Hauser, I believe, is in the hallway, and I believe Ms. Hauser is standing together.
Why is everybody in the hallway? What's going on out there? Does anybody know where Mr. Hauser is? Pardon?
He just ran out.
My husband.
Did you see him, Mr.
Coming.
Today?
Good morning, Your Honor. Attorney Matt Hauser on behalf of Mr. Dan McNally. Poorly timed restroom break.
All right, where are we? Mooney, you're waiving your right to a preliminary examination?
Yes, I am, Your Honor.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, I understand, Your Honor.
And you understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
I understand, Your Honor.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the single count. As to the circuit court arraignment, you waive formal reading, your client stands mute at this time.
Yes, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial will be set for
January 21st at 1:30 before Judge Conlon.
January 21st, 2026, 1:30 before Judge Conlon. Bond will continue. Thank you.
Thank you.
They'll need to sign off. Yes. And then that needs to just get to Ann, however we do that. Thank you.
Thank you very much, Your Honor.
All right, take care, sir. Court calls the case, People versus Hiba Al-Shabani.
People. Brian Bowling on behalf of Ms. Al-Shabani.
Just knock him out of the way. Go ahead. Your name?
Hiba Al-Shabani.
Judge, we're asking this matter to be sent for a preliminary examination. All discovery is complete. Yeah.
Don't speak. 20th. People have their witnesses available the 20th.
Yes, this
Preliminary examination in person will be set January 20th, 2026, 9 a.m. before Judge Freshour.
probably will not be in this courtroom. Yes, the same court.
Bond will continue.
Thank you, Judge.
Thank you.
I'll give you a notice for that date.
Court calls case of the People versus Giovanni Moot. 3 cases.
Good morning, Your Honor. James Fifelsky on behalf of Mr. Moot on case ending in 1665. Who else has those files?
Mr. Ballinger.
Mr. Ballinger.
Just adjourn.
Michael Gaddy, Assistant Public Defender for Mr. Moot.
And I believe everybody's requesting an adjournment of these procedure.
That's correct, Your Honor, for discovery.
And we have initiated an investigation as well, Your Honor, so that's going to take several weeks. So I'd just be asking for at least 2 weeks here.
You want 3 weeks?
Yes, please.
Is that going to be okay on the other matter?
I have a conflict. I'll be in Dearborn District Court on the 29th. I can do 2 weeks. I can't do 3.
Okay, well, I suppose we can start with 2 and then go from there. I have no problem with that.
January 22nd, 2026, 9 a.m.
Okay.
Bond continue.
Thank you, Your Honor, and apologies.
Thank you, Your Honor.
We did initiate the investigation.
I think there were 3. And you might want to check just to make sure that one didn't get put in with that. Court calls the case of the People versus Malik Al-Sadi.
Okay, welcome. And Stephanie Cannon, we have Mr. Al-Sadi. Could you please state your name for the record? Your Honor, I am asking for a brief adjournment. I do believe we're very close to resolution on this case. We just had to crank some things up the chain for him, so.
January 22nd, 2026, 9 a.m.
January 22nd.
Thank you.
Yeah.
Court calls the case, People, is he there?
Yeah. Thank you.
Court, thank you, sir. Court calls the case, People versus Alan Rogers.
Morning, Your Honor. Raymond Cook.
Good morning, Your Honor, and good morning to your staff. Barris Haddad on behalf of Mr. Rogers.
Thank you. And your name, sir?
Alan Rogers.
Thank you. All right, what are we doing on this?
Judge, he is scheduled to be transported hopefully tomorrow to an inpatient facility. So we're asking for a 4-week adjournment. After that treatment, he may have a way to keep this at district court.
So you're looking to adjourn this out about 4 weeks?
Yes,
Is that
sir.
correct, counsel?
Yes, Your Honor.
From the people, is that correct?
Yes, Your Honor.
Why don't we do it this way then? February 12th.
Okay.
2026, 9 a.m.
Thank you. Your Honor.
We'll continue. All right, thank you. Thank you, sir. Good luck to you. Court calls the case of the people versus Renee Andrews.
Good morning, Your Honor. Assistant Public Defender Don V. Lieb on behalf of Ms. Andrews. Ms. Andrews, can you please tell the court your name, ma'am?
Renee Andrews.
Thank you. All right.
And Your Honor, we're going to be requesting an adjournment today in order to have some further discussions with Ms. Andrews, as well as to review some media discovery.
January 29, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Christopher Thaxton.
Hey, Your Honor.
James
Fifowski on behalf of Mr. Thaxton, who is approaching.
Your name, sir?
Christopher Thaxton.
Thank you.
Your Honor, all discovery is in, and we would ask the court to set this for a preliminary examination.
People have their witnesses available the 20th.
That's fine.
Preliminary examination will be set January 20th, 2026, 9 a.m. before Judge Moore. Bond continued. Thank you.
Thank you, Your Honor.
I'll stop. Court calls case people versus Rick Artuso.
Right here.
It's another Ballinger case. He's asking for an adjournment, so.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Artuso, Your Honor.
Mr. Artuso, can you state your name, please, sir?
Rick Artuso.
All right, he's waiting a response on this. What I will do, adjourn the matter out to January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Artuso.
Okay, thank you.
Court calls the case, people versus Mark Tipsword.
And then on behalf of Your Honor.
Proceeds to substituting in for the Washington County Public Defender's Office, appearing on behalf and with Mark Tipsword.
And I sign these substitute. All right, what are we doing?
Your Honor, may Ms. Senator and I approach, please?
Okay.
Your son said you wanted to check it out for appeals.
Okay. On this matter, what I'm going to do, and the record should be at a bench conference, probable cause conference will be adjourned to January 29th, 2026, 9 a.m. We also discussed in some of the issues regarding the bond violation. The courts is satisfied that there was not actually a bond violation in this case, and so I will not be finding that he violated his bond. His previous bond will be reinstated. I'll need a new GPS order so that he has that on him prior to release. Yes,
And Your Honor, I'm sorry, did you say January 29th?
yes. Will
And
that work?
Is there, that's perfect.
Okay.
For that.
All right. And so we'll do that with his bond and we'll reinstate that and then we'll check, my staff check on that other hold. All right.
Thank you.
Thank you.
So you're gonna get.
Court calls the case People versus Charles Cobb.
That's other.
Yeah, he's gonna have to.
Good morning, Your Honor. Christina Saxon, standing in for Attorney of Record Kyle Cradell with Mr. Cobb. Mr. Cobb, please state your full name for the court.
Charles Cobb. Thank you. You're asking for an adjournment.
Yes, Your Honor.
Additional discovery. January 22nd, 2026, 9 a.m. Bond continued.
I'm sorry, Your Honor.
22nd.
Okay, thank you.
You're all set, sir. Court calls the case People versus Joseph Bonville.
Did you say Bonville?
Bonville.
Raymond Code for the people.
Tina Saxon for Joseph Bonville.
Oh, there's two of them. This is your name, sir?
Joseph Bonville.
All right, that's right. All right.
Your Honor, originally, there was a request for an adjournment for another PCC, but we're going to instead ask for a preliminary exam date. I do believe I have all discovery.
All right, here you go. People have their witnesses available on the 20th.
Sure, that's your honor.
Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Margaret Patowski. Is she, where is she? Oh, is she here? And she's not there right now. All right, we'll wait for her to appear back. Court calls the case People versus Shayna Desir.
Morning, on the Raymond Code for the people.
Desir,
She's trying to cut the blood.
she what? She's outside the door. Well, I'm not holding the hearing out there though.
Well, come.
Seriously?
Morning, Your Honor. Christina Saxon for Shania Desir.
Your name?
Shania Desir.
You're requesting an adjournment?
For both cases.
There, maybe speak to the officers. Will 3 weeks be enough time for you to get that done?
Yes, your honor.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continues.
Thank you, Your Honor. Have a good day.
You do the same. Court does call the case People versus Mary Barney.
And then on behalf of people, Assistant Public Defender Chelsea Richfield with and on behalf of Mary Barney. Please state your,
Mary Barney.
Thank you. All right, what are we doing?
we are asking for a preliminary exam in all cases.
In both matters?
Yes, Your Honor.
All right. And discovery is complete in both cases?
Your Honor, on the arson case, we're still waiting one more supplement report with the re-interview with victims. I'm hoping to have that by next week.
We would ask for a preliminary exam as soon as possible.
Well, I don't mind setting a preliminary examination. It wants that report. If you don't have that report, you're not going to be entitled to an adjournment based upon that.
Would you like to wait for it or have it out?
I don't know what that means.
So if we get to the date of the preliminary exam and we don't have that report,
You hope to have it next week. So what I would then suggest, or maybe propose to, is adjourn this out. I'll give you a 1-week adjournment on this. Then you can look at the report, go through that with your client, figure out it strategically or whatever, what you want to do, and then I can set the exam. But
I guess so. That's fine, Your Honor.
that'll work. Okay. The probable cause conference in this case, January 15th, 2026, 9 a.m. Continue.
Thank you.
Thank you.
Yeah.
Court does call the case People versus Margaret Petoskey.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Petoskey. Your Honor, I reached out.
It is Ms. Gaines, it is a pleasure seeing you.
It is a
I
pleasure.
haven't had her before me for a while.
It is a pleasure to see you.
All of these people were making me miserable, and now I'm happy. Thank you, Ms.
That's
Gaines.
good. That's good. I am glad to be
Ms.
able.
Petoskey goes, that's good.
I'm glad to be able to bring that quiet to you.
All right.
Petoskey.
Ms. Petoskey, can you state your name, please?
I'm Margaret Ann Petoskey.
Thank you. All right, what are we doing?
Your Honor, I did reach out to the Huron Valley Women's Prison by email and by left a voicemail message, and I was unable to arrange an appointment to meet with Ms. Petoskey. I do have an offer to go over with her, and I anticipate at our next hearing, we will be able to move forward. So I'm requesting an adjournment.
All right. You told them you were Joy Gaines and they wouldn't let you in? Really? Oh, never mind.
I probably should
Never
have
mind.
said it was going to be.
All right. Well, the 29th, you think that'll give you enough time to get in here and do it? Okay.
Yes, thank you.
So I will adjourn this out January 29th, 2026, 9 a.m. Bond will continue. Thank you, Ms. Petoskey.
Thank you.
Thank you so much. Have a great day.
You too. Court does call the case. People versus DeJure, Bond Sanders. Well.
Good morning, Your Honor. Veronica Glenn requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Welcome back. Happy New Year.
Happy New Year.
I'm glad you chose the probate clinic to practice.
Me too.
All right. Permission to practice is granted.
Thank you. Your Honor, we are asking to set up preliminary examination.
In both cases?
Yes.
You want them set in both?
Yes.
Yes. All discovery is complete.
Yes.
People have their witnesses available the 20th? All right. Preliminary examination in person, January 20th, 2026, 9 a.m. That is before Judge Moore. In both cases.
Thank you, Your Honor.
All right. Thank you. Court calls the case of the People versus Demarion White. He's in zone.
Yeah.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Demarion White is appearing via Zoom from the juvenile facility.
Sir, please state your name.
Demarion White.
Thank you.
Your Honor, myself and Mr. Childers have spoken, as well as my client. We are asking for an adjournment till the 27th, I believe. 29th, I'm sorry, I got the date wrong, yes.
All right. Is there a co-defendant on this one?
Not that I'm aware.
There's not, okay.
That's a different, I think you said that last time. It's a different case, Judge.
Yeah, I think you're right. January 29th, 2026, 9 a.m. On continue.
Thank you, Your Honor.
Thank you.
All right, Demarion, I'll see you in a couple days.
Court does call the case People versus Linda Bryant.
And I ask for permission for Ms. Bryant to sit down.
Absolutely. She looks at.
Your Honor, I'm Michael Gaddy for the Public Defender's Office for Ms. Bryant, Your Honor.
Your name, ma'am?
Linda Bryant.
Thank you. All right, what are we doing?
Your Honor, I'm asking for an adjournment in this matter to go over the information with Ms. Bryant. I have collected good contact for her today.
Okay, very good. Probable cause conference, January 29th, 2026, 9 a.m. All right, bond will continue. All right, thank you, ma'am.
Here you go, Ms. Bryant.
Okay. I need to see it. I need to get home and get my shot.
You're all set.
Okay.
All right.
Okay. You remember.
Yes, sir.
Okay.
In your hand?
You gonna help her out? Or you just, what? He didn't come over to you and say, get up and get out, did he? Did you say that to her? No? Okay, I'm just checking. Just want people treated respectfully. You know, okay. Court calls the case, People versus Melinda Baker.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Baker, Your Honor, who I do believe is here by Zoom.
She is. Ma'am, if you could state your name.
Melinda Baker.
Thank you.
Your Honor, I'm asking for an adjournment of this matter. I have spoken with Ms. Baker. There is some investigation I need to do that's ancillary to this case.
You're doing okay. Probable cause conference will be adjourned then to February 5th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
Thank you, man. Court calls the case People versus Jeffrey Bushinger. Ms. Cannon isn't working today.
Veronica Glenn on behalf of Mr. Businger, can you please state your name for the record, please?
Here. Thank you. All right, what are we doing?
We would like to set this for preliminary exam.
Discovery is complete.
Yes.
People have their witnesses available the 20th.
Yes, Your Honor. May I approach Ms. Cannon for something?
Sure, come on up. Why you gotta bring Cannon now? Come on, Glenn. Glenn, get it. Why are you waiting for her? I gave you permission to practice. Continue.
Thank you, Your Honor.
Thank you. Court does call the cases of the People versus Spencer Norton.
Good morning, Your Honor. Edward Dukes on behalf of Spencer Norton and 1768.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Norton on the other matter ending in 1856.
And Mr. Norton is refusing to join us.
He is. However, we were looking for an adjournment, so we'll try and get his presence here at the next hearing.
For the record, I did speak with Mr. Norton yesterday. He did ask that the matter with me be set for preliminary examination, but I understand him not appearing.
You'll need to be here for me to do that.
Yep, so we will do that.
Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Court does call the case of the People versus David Childs. Two cases.
People, Your Honor.
Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Senior Assistant Public Defender Joy Gaines.
Happy New Year. Welcome back. Practice is great.
Thank you, Your Honor. I hope you had a good New Year.
Starting out, we're okay. Yes, I did. Thank you. Your name, sir?
David Childs.
Your Honor, requesting to adjourn this matter, we have yet to receive the police report in case ending in 2509, and media discovery in both cases are still not.
Yes, okay. Probable cause conference then will be adjourned to the 22nd, January 22nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus
I have no way of knowing that. Is that, are you the,
You continue.
you were indicted under the name of Ashley Fields. Is that you?
Yes.
Ms. Fields, we are scheduled today for a pretrial conference. It's my understanding, and I just found out a few moments ago that you declined the appointment of counsel.
Yes.
Why would you do that?
Because Jesus Christ has my back and I don't need counsel.
You are charged with an offense. Let me ask you this. Have you ever, do you have any training in the law?
No.
You ever went to law school? You're not authorized to practice law in the state of Ohio. Is that correct?
Correct.
Oh, yeah. You have a right to represent yourself, but you understand that here in this courtroom, we play by certain rules, and the rules are very specific, the rules of evidence and the rules of procedure. Do you understand what those rules are?
Yes.
You understand the rules of evidence and the rules of procedure?
Yes.
Okay, because you understand that if you choose to represent yourself in this matter, you'll be held to the same standard, and I will enforce the rules equally against you as I do against the prosecutor. You understand that?
Yes.
And you want to represent yourself?
Yes.
All right.
Your Honor, I'll just note for the record that at her arraignment on Friday, I raised an issue of competency based on her statements to the court during arraignment. This had been originally set for a pretrial later in the month. Based on her statements at arraignment and my suggestion of competency, I believe Magistrate Fessel had emailed Ms. Yazel asking for a sooner date for the court to kind of evaluate that and determine what was appropriate moving forward.
I think that's probably a good idea, Ms. Fields. What do you say you go by now?
Bailey.
Why did you change your name to Bailey?
I got married in here.
In here?
Well, in the jail facility.
Who married you?
Robert Todd Bailey.
No. What authority figure married you?
Jesus.
All right. Well, the court does not, the state of Ohio does not recognize that. And again, you can throw out the name of Jesus. I personally am a believer, but that doesn't really change what you're facing here. And you seem to be taking this very, very lightly. So I am a little bit concerned. So I will order a competency evaluation. Can you give me, I see what the charges are. Could you give me an allegation of what the underlying alleged facts are?
Yes, Your Honor. She trespassed into Mr. Bailey's residence. She was found sitting at the dining room table in the victim's home. The victim explained that he arrived home to find his dog in the front yard with the front door open. He asked the defendant to leave after finding her inside. He does not know the defendant other than an interaction with his neighbor. I believe the defendant used to live with his neighbor, be in a relationship of some sort with his neighbor. But otherwise, the victim does not have any relationship or knowledge of the defendant. She also advised that law enforcement that she does not know the victim other than living near him. And she again represented to the court on Friday that they had gotten married, which of course the victim says did not occur.
Let's do this. Justin, would you get out an affidavit of indigency for me, please? Ms. Fields, Mr. Logston is going to hand you a document. It's an affidavit of indigency. It simply tells me that you do not have the money, the funds to hire your own attorney. Okay. I'm asking you to sign that. I'm not going to appoint you an attorney because I'll honor your wishes as long as you understand that if you lose this case and you end up getting sentenced and you want to appeal the fact that that your attorney, you were ineffective, you can't use that as grounds for an appeal. You understand that? If you represent yourself, you can't say, well, I didn't do a very good job. You understand that?
Yes, sir.
Okay, so I'm going to have Mr. Logs. What I'm going to do is I'm going to appoint what's called standby counsel. So I'm going to get someone involved in this, an attorney at law that knows the rules, knows the how to look at the evidence and stuff. I'm going to appoint one, and they won't be representing you yet, but I'm going to appoint them as standby counsel to get them involved right now. So if you'll please sign that for me, please. It's just, again, it's just telling me you don't have the money to hire an attorney.
Your Honor, are we gonna wait to do a formal waiver of counsel until the competency report comes back?
I think that's probably wise. All right, what I'm going to do is I'm going to find that you're indigent today for the purposes of retaining a counsel, and I'm going to appoint Attorney Chloe Kirby to represent you in this matter, okay? I'm sorry, to be a standby counsel. I want to make sure we get the terms correct. So I'm going to appoint Ms. Kirby as standby counsel. I am going to order a competency assessment, so someone will be over to the jail to speak with you. You do need to cooperate with them, okay?
Okay.
All right, anything else, Ms. Nicholson, we can do today?
No, Your Honor.
All right, very good. Thank you all.
Thank you. God bless you guys.
Judge, I have spoken to Ms. Moore about this case, and it is my understanding that she's still waiting on the lab results to come back from the blood draw. So we're still waiting on that piece of evidence. And then I am still working through the media and everything else.
Okay. So you're asking for how much time?
How long do you think? Sometimes we could maybe do 4 or 5 weeks just to see where we're at. And then if we don't have them back by then that could just be another time.
Okay, we'll reset it 5 weeks, okay, for an announcement. And what do we have here as far as this 0.086? What are we doing about driving?
He uses Lyft and Uber, and then I believe somebody drove her to court today, but she is not operating a motor vehicle.
Is that right?
Yes.
Yes. Because you can't operate a motor vehicle without an interlock device. If you did, it would be catastrophic for you.
And she's aware of that, Judge.
We would revoke your bond. I would
Yes, sir.
revoke your bond and we'd sit this out until we get around and get it resolved. You know, we're gonna test her here just to be on the safe side, okay? Before she leaves, get a resetting. Thank you. Pamela LeBeau.
Thank you, Judge.
It's been.
Judge? I believe that's going to be a dismissal.
Today?
Yes, sir. So I think they just sent it to you.
I just sent it, Judge.
That's right. It's up there.
So what did you learn?
Learned a lot doing parenting classes.
Good things, right?
Yes.
Not bad things, good things. And give me a few things that you think everybody would be wise to use as a practice in being a good parent.
Being a good parent, when I learned in parenting classes, you don't always have to basically talk to them, grow up. You could bring them to the side and talk to them and take things like pads and stuff, and you got to motivate them to do this and give them like a little snack, when they have a disability.
Oh yeah, reward
Yeah.
for good behavior.
And
That's the way we do it up here too.
And he actually been doing good. And right now he's at Pathways, but he's about to go back to another school.
Okay. Grades, how about those?
Not too good because he's not reading, but we getting him on a program.
Oh, okay. That's important.
Yes, sir.
And as you don't want him to feel that he's different. And we're all different, unique, but different in a bad way.
Right.
By not keeping up good grades. And that's what parents do.
They actually been working with him, so he really been doing.
Reading is important, math.
It is.
Yeah.
And he need help with it. He needs good help.
When that gets sent over, what I'm going to do is I'll just sign it and dismiss the case based upon the agreement that the parties had that the satisfactory completion by Ms. LeBeau of this parenting class resolves this case. And these are the kinds of lessons that even you get to use, the rest of your life in a better way.
Right.
And that's what we want.
And I also signed this up for me and him to go too.
Oh, that's a good thing.
Mhm.
Yeah.
Me and him.
As a team.
Yeah, as a team. Because I couldn't do it with him. I did it by myself, but now it's gonna be me and him. So we're gonna start fresh next week. Me and him.
That's good. Yeah. That's important.
1997.
I made straight A's in school. Now, all my other letters were crooked, but I made sure that all my A's were straight.
Right.
My grandchildren love that joke. And I think it's
Oh, I'm going to borrow it.
well, that's a good thing. Good for you and good for your family.
Yes,
Best wishes to you. And when I get that, I'll sign it. You don't need to be here. You can go home and keep doing great things. Okay.
Yes,
Best wishes to you and your family. Happy New Year.
Thank you.
Thanks, man. We're gonna lay on this other S. So it's being run to make sure that the lady is not you ingesting something that would be inappropriate for mom, as well as her health. So we're in short recess. And we pick up a trial at 9:30 here. Yeah. Aggravated kidnapping. Don't have those too often. But it is in the latter stages of the presentment of that case. And Sharp says, stand by. I had to run in. Sad. Give me the file, please. Which is not appropriate. And the court was motivated to do this because I'm looking at the affidavit, and the affidavit states that the indications from the officer who was at the scene indicated that you might be under an influence of more than just alcohol. Now, they did test you and you did have alcohol in your system, but your bond condition is not to commit any offenses while on bond. And tetrahydrocannabinol marijuana is an offense to have in your system, to consume it without a doctor's order. And what is her bond, please?
It's $3,000. And also, Judge, it does look like she has a warrant for her arrest at a JP court, and we'll have to commit that as well.
You've got all kinds of fires here you're going to have to find. There's a warrant for your arrest for something else, apparently. So you're going to be taken into custody. Your bond is going to be doubled to $6,000, 3 to 6. She has to have a drug patch as a condition of bond, as well as an intoxilizer, interlock device on any alcohol, for any automobile you operate. How many children do you have, ma'am? What are their ages?
7, 6, and 2.
7, 6, and 2. Okay. We just had Christmas, and what's the greatest gift you can give to your child? A good example, role modeling, setting an example. Your children will emulate you. Use drugs, they'll use drugs. They'll find that to be okay to do. You don't want that. You've got to set an example, man. You are a parent. You're not living your life on your own. You've got at least 3 children dependent upon you over here. So it was driving automobile operating speeding ticket she received. She did not appear, so they issued a warrant out of it. Looks like Justice Courts, precinct 1, place 1, Jefferson County, for failing to appear. So you got to deal with that. But again, your bond is doubled to $6,000. You have to have a drug patch that as a condition of your bond. And you're going to have the interlocking lights on any vehicle you operate. This is not a good way to start this case, nor is it the proper way to exhibit proper parenting. You have to be a role model, whether you like it or not. Nature causes parents to be role models to their children. So if you're going to be using drugs and not following the rules, then don't expect your children to. You can't get upset if they are, because they're learning bad lessons. It's so easy. You know what the right choices are. Make them. Not only for you, but for the 3 children that you brought into the world. You understand? You gotta role model and be responsible and set a good example, because they're going to follow the example you set. That's why you have to set your example. So fix this. Honestly, there's the next thing. We're going to and the investigators can come to you and start inquiring about where you getting your drugs. You want to start talking about that? Well, then that's what you do when you dance with the devil, which is what drugs are, illegal drugs are. You're going to pay a price. Don't do that. You've got children at home to take care of, plus yourself. And you've got this is a state jail felony, which means you can be sentenced up to 2 years in the state jail. These are all serious, and they're all fixable. So fix it. She's a very good lawyer, and make sure it would be wise for you to heed her advice. But this is what's going to happen. You're going to be taken into custody now. Is somebody or your children here with you by any chance? Oh,
Yes.
Judge, if I may just make a request. Instead of, she has the warrant out of JP courts, she's going in custody anyways, instead of revoking and doubling her vote, given that I'm court appointed and she is indigent. My request would be not to punish her fiscally in terms of making her post another bond, but if I may suggest just adding those bond conditions that you've already added to the new bond, but instead keeping her current bond, but taking her on that JP warrant.
I'm going to treat her like I treat everybody.
I'm saying, Judge, just a request that I was make.
This is all about fairness, and everybody pays a price no matter what it is. I don't know if they're giving the drugs free out on the street, but I don't think they are. You have to use your money wisely, and foremost is family. It's the family, and this is $3,000. It's one of the lowest bonds I've had in this court, and I'm just doubling it like I'm treating her like everybody else. And that's because everybody else is going to come in and just say, I want to be given the treatment because I'm indigent, but I'm going to commit violations and I'm going to be treated differently. So it's a price you pay. That's why I urge people to follow them, and then it works out fine. Okay. That is all. Thank you. You're no sus in this. Do better, please. I know you can. All right, we are going to get ready for this aggravated kidnapping case.
At the request of Officer Torek to terminate the supervision of Mr. Ingram. Ms. Nicholson, does the state have a position?
Your Honor, we did have contact with the victim who did acknowledge that restitution was paid in full and he was happy with that. He will defer to the court. The state would object to early termination just based on the nature of the case and the underlying facts and the injury suffered by the victim.
Okay. Officer Torek, anything else? Mr. Ingram, is there anything you'd like to say?
No, it was a bad decision on my behalf. I've tried to be a man about it. I've did everything you wanted me to do, and I think that my POs wanted me to do. I'm entertaining the job. I'm sorry that it happened, and I'd like to be able to move on with my life and leave this in the past.
Okay. All right. Court will note that this originally charged as a F2 was modified, reduced to an F3, that the sentence issued by the court included a significant period of incarceration for Mr. Ingram. He has complied with all the terms and conditions of his supervision to date, including paying restitution in full. So at this time, the court is going to terminate the supervision. All right. Anything else? Congratulations and good luck to you.
Thank you.
And we were in a truck with us. Yeah.
Is it Deja Banbury? Why, even when she's not involved, is there a delay in Cannon's cases? Where's Miss Banbury? Miss Banbury on Zoom?
She's here.
She has not checked in.
No, I saw her this morning.
You saw who?
I thought I saw Miss Benbury.
Going back up together. It's tense. Do you recall whenever you feel like it?
January 29th, 2026, 9 a.m. Fine, continue.
Thank you.
Thank you. Court calls the case, People versus James Cobbs.
And then we have people.
Assistant Public Defender Davi Lebo on behalf of Mr. Cobbs, who's approaching. Mr. Cobbs, can you tell the court your name, sir?
James Cobbs. Thank you.
And Your Honor, we would like to set this matter for preliminary examination, please.
Good morning, Your Honor. James Dick on behalf of Mr. Torres.
Good morning. I do see Mr. Torres is with us. Mr. Dick, do we have a resolution of this matter?
Not at present, Your Honor. We are just awaiting some video discovery that has been requested. The prosecution has requested it. And I do not anticipate we need all that long to get it and review it. Perhaps 30 days.
Just to be safe, we'll take a trip. Mr. Fortier, and what's the status of the video discovery?
Judge, it was just requested today. This was a case that originated in 2022. Looks like it went into bench warrant status a couple different times before it got back to us here. So the video was never requested back then. So I just did request it today. So we should have it within the week or within a week.
All right. What have I got at the end of January? The 26th in the morning. Monday, January 26th at 9 a.m. Any conflicts there?
None for me. No, Your Honor. I will be in your courtroom already.
All right. We'll adjourn the status conference until January 26th at 9 a.m. Hopefully you've got everything by then, and we'll have a resolution then. Thank you.
Thank you, Your Honor.
State of Michigan versus Matthew Wiltshire, file 25-43488-SD. I do see Mr. Wiltshire is with us.
Yes. James Dick on behalf of Mr. Wiltshire, Your Honor.
All right, thank you. Looks like this is set for a jury trial on January the 21st. Are we going to trial or are we gonna have a plea, Mr. Dick?
Your Honor, so I was discussing with Mr. Fortier this morning about this case, and I understand that he was just assigned this case, and there's some of the discovery that perhaps could resolve it short of trial. That Mr. Fortier and I would like to go over together. It was otherwise our intention to proceed to trial.
So what would you like to do today? Are you this case is scheduled for the 21st, which is
Yes.
Slightly less than 2 weeks away. Do you want me to, we got any room on the 15th?
No, you're out of the office on the
That's
15th.
right.
This is the last available day before the 21st. Unless they get room tomorrow, but I don't know if that's enough time for them to discuss.
Yeah. I'm gone both the 15th and the 16th next week.
Yep.
No room on Monday, the 19th.
Closed Monday the 19th.
They tell you about.
Well, Mr. Dick, here's my conundrum. There is no court time for me to get you in before the 21st. So I either lose a trial day or we have a trial. Which would you like to do?
Yeah, okay, so I did tell you the whole story.
If you want some time, I can give you some time, but I'm going to cancel the jury trial. And I hate to do that. I hate to do that, but that's the reality of what my docket looks like right now.
Yes.
So what I'm gonna do then is I'm going to not call in the jury, and I'm gonna have the parties show up on the 21st and see if we can resolve the case then. If not,
Your Honor.
we'll reschedule. Sorry,
I didn't mean to interrupt. Go ahead.
So if we can't get a plea or another resolution done on the 21st, I'll simply reschedule it for a jury trial at that time. Mr. Wiltshire, is there something else that you need to say?
Yeah, I just had a quick question about that. I'm like 3.5 hours away. So on the 21st, if there's not a trial, will it still be over Zoom or do I have to drive up there?
I'll let you have it over Zoom. Other than the trials will be in person, but everything else we can do over Zoom. So I'm going to call off the witnesses and the jurors and all that kind of stuff so that you guys can have an opportunity to resolve things. But I'm not going to be very lenient in additional requests for adjournment after that. I hate losing a jury trial date this way anyway. So, all right.
Judge, we do have a second jury trial scheduled for that Wednesday.
Trying to think of a good way.
So throw in that afternoon and hope the first one's done by 4 o'clock.
How about if we do it at noon?
Okay.
Maybe 12:30 would be easier because we don't always get done right at noon. All right, we're going to reschedule this for 12:30 on January 21st. So instead of 8:30 when the trial would be, we're going to do it for 12:30 because I'm told that there's a second jury trial already scheduled that day. So I'm not going to be losing a trial. I'm just going to be switching trials, and then we'll have you guys on Zoom at 12:30.
Thank you, Your Honor.
All right. You have any questions, Mr. Wiltshire?
No, sir. Thank you.
All right. I'll see everybody on the 21st at 12:30.
Thank you.
State of Michigan versus Jennifer Malik, file 25-44134-SM. I do see Ms. Malik is with us.
Yes, James Dick on behalf of Ms. Malik, Your Honor.
We have a resolution of this matter, Mr. Dick?
Yes, we do, Your Honor. Ms. Malik will be pleading guilty to an added count of attempted retail fraud in exchange for a dismissal of the original count 1.
That would be attempted retail fraud, 3rd degree.
Yes, Your Honor. My apologies.
Oh, that's all right.
That is accurate, Judge.
Thank you. Ms. Malik, you've heard what the attorneys have said. Is that what you want to do?
Yes, Your Honor.
All right, my understanding of the agreement is that you would be pleading to what's called attempted retail fraud in the third degree. That is a less serious offense, and that the more serious original charge of retail fraud in the third degree would be dismissed. Is that your understanding of the agreement as well?
Yes, Your Honor.
If you want to take advantage of that agreement, you'd be giving up your right to have a trial and all of the trial rights that go with that. Do you understand that?
Yes, Your Honor.
Those trial rights that you'd be giving up include the right to have your attorney represent you at trial, the right to have a trial by a judge or a jury, the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. In addition, at trial, you'd be giving up your right to testify yourself or to remain silent. And if you chose to remain silent, that silence could not be used against you. At a trial, you'd have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at a trial, and one of the trial rights that you'd be giving up is your right to automatically appeal any error at that trial. If you enter a plea, you're limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor, I do.
Do you have any questions about any of those rights?
No, sir.
All right. Knowing all of that, is it still your desire to enter into this plea agreement?
Yes, Your Honor.
All right, I'm going to take some testimony from you. So can I have you raise your right hand so I can swear you in? You swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, go ahead and put your hand down. Has anybody promised you anything other than this plea agreement in order to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
All right. The amended charge of attempted retail fraud in the third degree would read as follows. It would say that on or about October the 27th of 2025 in the city of Gaylord in Otsego County at the Gaylord Walmart, that you did attempt to commit the crime of retail fraud by going into the Walmart store and taking property that was offered for sale and then not properly paying for it. Is that what happened?
Yes, Your Honor.
What property did you take from the Walmart store on that date?
I took some food and some jeans, clothing, and
those. Go ahead.
And a pair of slippers.
All right. All of those items were offered for sale on the shelves of the store?
Yes, Your Honor.
And then you did not pay for them and walked out of the store with those items?
I didn't walk all the way out of the store, but they stopped me before I walked all the way out of the store.
All right. And you were trying to walk out of the store, is that correct?
Yes.
Right, so that's why it was an attempt and not a completed action, right?
Yes.
Okay. Either counsel have any additional factual basis questions?
No, Your Honor.
No, Your Honor.
Either counsel aware of any other promises, threats, or inducements not stated on the record?
No, Your Honor.
None, Your Honor, and you have complied with the court rule.
Thank you very much.
Yes.
All right. I do find that Ms. Malik has given me a proper factual basis for attempted retail fraud, third degree, in that she's indicated that she stole a number of items from the Walmart store while it was open for business, and that the items were offered for sale. I can take judicial notice that those items are less than $200 in value, which qualifies for the retail fraud third degree. So I will accept the plea to attempted retail fraud third degree and find that it was knowingly, intelligently, and voluntarily given to me based on her answers to my questions. Mr. Dick, do you wish to proceed directly to sentencing?
Yes, Your Honor, if you would.
Ms. Malik, I'm going to listen to what the attorneys have to say about what the potential sentence should be. And then after you've heard the same thing, I'm going to give you an opportunity to tell me anything else that you want me to know. So I'll start with Mr. Fortier.
Well, Judge, other than a delayed sentence for a misdemeanor larceny in 2008, there's no other noted criminal history. The total amount of the merchandise attempted to be taken was $66 from Walmart. That property was recovered and able to be resold. So there is no request for any restitution. As far as an appropriate sentence for this one, I would leave it up to the court to utilize its discretion in fashioning an appropriate sentence, given the facts and circumstances.
Thank you. Mr. Dick, your comments?
Yes, Your Honor. So, Your Honor, Ms. Malik, she unfortunately lives somewhat in poverty here. She does live solely on disability and any government assistance that she is able to obtain. Her disability is approximately $800 per month, and she already has at least $600 a month in bills. She struggles financially due to her circumstances. She was in a severe car accident back in 1999 and has been on medication since, which does affect her memory. So her mother has been the person who's been helping her with things in her life for quite some time, but her mother's recently passed. Miss Malik, she is dependent on pain medication as a result of that accident 26 or 27 years ago here. And she does not blame what has happened on that. However, she's ashamed of it. But under the circumstances, Your Honor, I would ask that the court takes note of the what was written in the police report by the officer. Ms. Malik did tell the officer that she was taking the jeans because of the cold weather. The officer noted that it was 47 degrees and she was wearing shorts. While this is not acceptable behavior, I truly believe, Your Honor, that this was a necessity, a survival thing more than intent to commit some criminal act that was meant to harm anybody. With that being said, Your Honor, we do understand that it is a criminal offense and whatnot, but we would just ask that the court perhaps consider her position when assessing fines and costs. And if the court does require some period of probation here, we would ask that the court considers waiving the probationary fees.
All right. Thank you, Mr. Dick. Ms. Malik, yes, you have the right to address me as well. Is there anything else that you want to say?
I did write a letter, if that's okay if I read it.
Yep.
I'm nervous, I'm sorry.
It's all right.
Okay. On October 27th, I made a horrible and life-changing mistake. I took food and clothing from Walmart that I did not pay for, and I am deeply ashamed. I have severe depression and anxiety from the disabilities and pain that I face every day, and I was already feeling worried and overwhelmed about my financial situation. When I learned that my food benefits were probably going to be stopped due to the government shutdown, I panicked and made a decision I sincerely regret. But my struggles are no excuse, and I know what I did was wrong. I take full responsibility for my actions, and I am extremely remorseful for what I've done. Since then, I've only made my anxiety and depression worse. I've gotten little sleep, living with the guilt of knowing I made such a huge mistake. I've not only let myself down, I've let Walmart down, the store I depend on so much for low-cost groceries and more. I've let Gaylord down, a community that deserves better than this. I've let my brother down, who helps me and guides me, especially since I lost my mom and the one who took care of me because of my disabilities. Since that day, I've lived with regret and have tried to find ways to make up for what I've done. I've donated clothing that I cannot wear to Goodwill, to help others who may be in the same position as me. I've talked to my counselor about how I can not only make amends for this, but how I can become a better and stronger person as a result. In the end, I am sorry to Walmart, the Gaylord community, and to everyone I've let down. This is not who I am or ever want to be. I promise to never make such a horrible choice again. And I promise to do everything I can to become a better person and to make this up to those I've affected. Thank you for your time and consideration, Your Honor.
Thank you, Ms. Malik. That was a well-written letter. I appreciate the thought that went into that. How long have you lived in the Gaylord area?
I actually live in Petoskey, but I go to Gaylord for counseling and for other things.
All right. Well, I believe the same is true of Petoskey that's true of Gaylord, which is small northern Michigan communities are very giving. They are especially ready to help people that are in need, whether that be financial need, counseling needs, service work, whatever it is that they need. If you let them know that there is that need, they're more than happy to give whatever they can to assist you. You don't have to take things that you need. We'd be happy to give them to you. And I think you know that because you've mentioned Goodwill, which is you still have to buy things there, but they're very low cost things. There are other agencies that assist. Many of the churches have clothing or utility assistance. DHHS has utility assistance, rent assistance. There's a clothes closet, I believe, at DHHS and also here in Gaylord that gives out winter wear or clothing or whatever you need for the appropriate season. There is many different opportunities for you. If you need food, there's a food pantry here in Gaylord. If you need things to live and get by, I believe that Petoskey has many of those same types of helps that you need. So there's no reason other than feeling sorry for yourself for you to go out and actually steal anything. You need to get the help, then get the help. Okay. I believe that you simply made a bad choice. I'm not here to say that you're a bad person, but this is your one mulligan. This is your one bite at the apple. Okay. So I'm not going to do a lot to be mean to you or anything. I am going to put you on probation for a little while and make sure that you do some community service to give back to the community. Because I think that will help you feel better about yourself. And then I'm also going to require you, like you I believe are already, to go to do some counseling and to take what's called an economic crimes course, which is a video series about why people shoplift or steal kinds of things. So I want to educate you a little bit about those things. So the biggest thing I want to communicate to you is we get feeling bad about our circumstances and we have a little bit of a pity party. And instead of being strong and doing the right thing, we let that pity party help us make bad decisions. So now you know about how that works. I want you to do the things necessary to get stronger so you don't have to do that again in the future. Does that make sense?
Yes, Your Honor. Yes, absolutely.
All right. So I'm going to put you on probation for 3 months, 90 days. That's a reduced amount than I typically do because I don't think it's going to take you very long to get through what I'm going to ask you to do. And that will also reduce the cost to you as well. There's a probation oversight fee of $90 for that. There's a mandatory crime victim fee of $75, a mandatory justice assessment of $50. There is no restitution request. I'm going to reduce the court costs to $100 and reduce the fine to $50. There's a local fee of $15. Let me add all of that up for you. That's a total of $380. You can pay that over the course of your probation. You may perform community service work in lieu of some of those fines and costs at the discretion of the probation office. I'm also going to require you to do 10 hours of community service work. That can be done at a nonprofit or a public service agency, the animal shelter, things like that. You'll have to talk with your probation officer about where specifically to do it and how to record your hours. But I think doing the community service work will let you feel like you've done something to give something back, which will make you feel better about the acts that you took that were criminal. I'm going to require you to enroll in and successfully complete mental health counseling. I believe that you're already doing that, and so you may continue with your counselor, but I want that documented. I want you to discuss retail fraud, and I want you to take the economic crime class, which is a video class, and the probation department will talk with you about that. Are you able to work, ma'am?
No, I'm disabled.
Or is it, I didn't know if that was a full disability or not. Is that full disability?
Yes.
All right. I think if you complete those requirements, mental health counseling, the economic crime class, and 10 hours of community service work and pay your fines and costs, I think that will be sufficient. Do you have any questions for me?
No, Your Honor.
All right. I don't expect you to have any trouble getting this done. If you do have some issues where you find some of these things difficult to do, please contact your probation officer. Don't just simply wait and hope that it goes away, because it won't. You need to take the initiative to get that accomplished. All right, ma'am?
Yes, sir. I understand.
Let me give you the number for the probation department. You can call them tomorrow to set up an appointment or to communicate with them about your requirements. Do you have something to write with?
Yes, I do.
All right. 989-731-0215.
Okay.
All right. That's all for today then. Thank you.
Thank you so much, sir.
Did you give me the Cybo case back again because they're now here?
Yes.
All right. State of Michigan versus Matthew Cybo, file 25-44148-SD.
Good morning, Your Honor. Tia Barak on behalf of Mr. Cybo, who should be present via Zoom.
I don't see him on my screen yet.
I've asked him to unmute and start his video.
All right, I do see Mr. Cybo now. All right, counsel, have you had an opportunity to meet with the prosecutor's office and get an offer in this case?
I have not, Your Honor. I'm not sure if there is an offer that the people did want to put on the record.
It's for operating while visibly impaired.
Okay, I do believe that should be okay with my client. I don't know if we want to pass the matter, and I can go over that with him very quickly, but I don't see that being a problem.
Do you want me to put you in a breakout room with your client?
Yes, please.
All right, Mr. Cybo, a breakout room is a private area within the court's electronic communications. You would be able to talk to your attorney privately there. Once you're done, you'll come back into the courtroom and I'll recall your case. Any objection to talking with your client like that, Mr. Cybo? I assume not, so we'll put you in a breakout room. All right, we'll see you in a few minutes.
Thank you. Thank you, Your Honor.
State of Michigan versus Francis Bodwins, file 25-44013-SM. you see Mr. Bodwin's with us?
Francis Bodwins.
Bodwins, thank you. All right, Mr. Bodwins, do you have an attorney, sir?
Yes, Judge. Attorney Thomas Courts P77177. I just emailed over my appearance.
All right, it hasn't made it to the file that I have on the bench. Let me make a note on the documents that you're entering your appearance. All right, is there a resolution of this matter, Mr. Courts?
Judge, I want to be candid with the court. Unfortunately, no, there's not likely to be one. He has he's on felony probation in Wayne County, and basically the judge has let us know if he ends up taking a guilty plea, he's going to be facing some serious criminal time. So we're likely to proceed to trial if that's okay.
It is. Trial is set for the 21st. Are you going to be ready for it by then?
Yes, Judge, I'll make myself ready.
All right. I require a witness and exhibit list 14 days in advance. I require all evidentiary issues to be motioned and briefed within that same time period, 14 days in advance. I also require you to meet with the prosecutor or talk with the prosecutor and come up with a set of criminal jury instructions. Typically, the prosecutor prepares those ahead of time. If you have any objections, we'll deal with those. I try to deal with those at today's hearing, but you're just getting here today, so it's going to be a little bit difficult. So I'm going to put the onus on you to meet with the prosecutor and to resolve any issues with the jury instructions. At the very least, then I typically require you to be here at 8:30 on the day of trial. Trial will be in person here in Otsego County in Gaylord. And then if there's any last minute issues, we'll resolve them before the jury trial starts at 9 o'clock. Any questions about that process, sir?
Not at all, Judge. I sent over my witness list, which just contains my client, and we will resolve that with the prosecutor, and I appreciate it very much.
All right. Mr. Fortier, from your perspective, is there any other issues outstanding?
I don't believe so, Judge.
All right. I will see everybody then on the 21st at the jury trial.
Thank you, Judge.
Thank you very much.
Discovery complete.
It is, Your Honor.
People have their witnesses available the 20th.
We'll do our best, Your Honor.
Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Manuel Barnhouse.
Here, Your Honor.
Rob Dow, Assistant Prosecuting Attorney on behalf of People.
Monica Glenn on behalf of Mr. Barnhouse, who should be appearing by Zoom.
Yes. Sir, state your name.
Manuel Barnhouse.
All right. What are we doing on
Your
this?
Honor, we would like to request an adjournment in this matter.
Reason for the adjournment? I don't have a brief.
There are some new charges.
Probable cause conference will be adjourned to February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case, People versus Davian Gavin.
Andrew Childers, appearing on behalf of people.
Well, Senator Dobbs, yes, Mr. Gavin.
Your name, sir?
Davion Lamar Gavin.
Thank you.
And Your Honor, we do have an agreement to waive Mr. Gavin's preliminary examination with an agreement to felony HIDA at circuit court.
So he's waiving.
Yes, Your Honor, and I'm having him execute the form now, and I have reviewed the relevant rights with him.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
All right. People also waive their right. Examination having been waived, defendants bound over to circuit court, single count.
Thank you, Your Honor. We acknowledge receipt of the information, waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea. Pretrial will be set for January 21st, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor. Mr. Gavin would like me to address bond.
Go ahead.
Thank you, Your Honor. So Mr. Gavin indicates to me that his previous failure to appear, he had attempted to be present on Zoom, but didn't hear that his name was called. He does tell me that he would have stable housing, thing with a friend in Detroit. We would have no objection to home confinement tether. Additionally, Mr. Gavin has let me know that he has 2 jobs that he would be working if he's released, one at Motor Casino, one at McDonald's. He does tell me his life is significantly more stable than when he failed to appear.
But he failed to appear in 2024.
Correct, Your Honor.
And this is 2026.
It is, Your Honor.
Okay. So what was he doing for now approaching 2 years?
I was working. Like after they issued the bench warrant, I didn't know how to go about that. And so I started working at McDonald's right after. And
okay, so how'd you end up back in custody?
When we was driving, we was driving, and he got
whenever a story starts that way, it's not going to be good. Go ahead.
No, he got pulled over because they was doing like 90, and he didn't have his license, and his car insurance was suspended. And I was going to get him, and when I pulled in, they was letting him go, and then they asked for my ID. And when I gave him my ID, and they said I had an arrest warrant, and
that's how you got to take it in. So if that hadn't occurred, we still wouldn't be seeing you. Yeah, there really isn't a need to answer that, but you wouldn't have come in on your own because you said you didn't know how to, even though you had attorneys. I don't need a response from the people. Motion for bond reduction is denied. Bond will continue.
Thank you.
Court calls the case People versus Jessica. Is it Brasgala?
Brian Bowling on behalf of Ms. Brasgala, who should be present on Zoom, Judge.
Andrew Childers, appearing on behalf of people.
Brasgala?
You need to unmute, ma'am.
She's Samson.
Yeah, that is her, Judge.
Your name?
Jessica Brasgala.
Okay.
Your Honor, I'm asking for an adjournment for Ms. Brasgala to pick up and review discovery from my office. It's been
Pick it up
prepared.
and review.
Yes.
Probable cause conference, January 29, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the case People versus Joseph Griffin.
Mr. Griffin,
Who is approaching?
Your name, sir?
Joseph Griffin, Your Honor.
Thank you.
Your Honor, requesting to adjourn this matter. We don't have any media in this case.
Pardon?
We're adjourning this matter. Our office has yet to receive the media in Mr. Griffin's case.
Discovery or anything?
Yeah, the discovery.
And Your Honor, for that check, we do have a disc as well as some video online. We just need to create the media notice and get that over to defense counsel, so it should be pretty short.
Okay. Is there anything else holding him besides these two cases, or? That was a question.
Oh, to me?
Is he being held on anything else? Because that's gonna.
On his other cases, he's has an order for release to treatment, Your Honor.
Okay.
Judge, seeing that those located out of county rules from Van Buren and to Hampton, 2 of those are bond denied.
Got it. Okay. So, well, let me do this. Let me put these over to the 29th, 2026, a little bit further than I would, but he really wouldn't be going anywhere at 9 a.m. And his bond in these matters then will continue. Okay.
Thank you, Your Honor.
Thank you. I don't have green sheet, but I imagine he doesn't care. Yoo-hoo. Are we gonna get green sheets
Oh, yes.
like today?
Yes.
Did you already have them? No, don't you? Okay. She at least told the truth. Court calls the case, People versus John Brooks.
Hannah Mackey on behalf of Mr. Brooks. Mr. Brooks. Who is approaching? Please state your name.
John Brooks.
Thank you.
Your Honor, requesting to adjourn this matter to continue negotiations. And I have the green sheet for that one.
Exciting to see that. Probable cause conference will be adjourned January 29, 2026, 9 a.m. Bond continues.
Thank you.
Thank you.
I'll be in contact with your mom.
Court calls the cases of the People versus Carlos Hicks. Please.
Sherilyn Foster Tucker on behalf of Carlos Hicks on cases 1294 and 2223.
On the other case.
Here's the last one. There should be a substitution on file. Okay. I don't know.
Yeah, you guys are on this other case.
Hannah Mackey on behalf of Mr. Hicks.
Your name, sir?
How you doing, Joe? My name is Carlos Hicks.
Thank you, sir.
Well,
Troy Gaines, Senior Assistant Public Defender representing Mr. Hicks' mom.
All right, what are we doing?
Your Honor, we did just receive this case. I've spoken with Mr. Cook. I know that there is some video discovery that he indicates he can get to us in the next couple of days. Mr. Hicks does want his cases set for exam.
Okay. But you haven't seen the video nor reviewed it.
Not yet.
So then what do you want? And he would understand that if it doesn't get over there, that's not going to be the basis for an adjournment. You
That is
understand that, Mr. Hicks? Okay.
yes.
And I would, so that you know, for consideration, adjourn it 1 week and then set it after you get a chance to look at it and talk with him about it. So that's also an option for you.
Did you?
Ms. Gaines, on his other matter, what did you guys want to do on that?
Your Honor, I believe it was previously set for a preliminary exam, but I did think
it
to
wasn't
get withdrawn from that case as well. So I'm just going to.
that his. Let's see. And then he. Did he not appear? Yes. Okay, I see. So back in December of 25, he didn't appear. Got a bench warrant. Who was that set? Okay.
This matter was not on our docket originally. So I have also not had a chance to speak to Mr. Hicks about that past history, but I did speak to Mr. Cook and
Right,
when it
and
was brought
so that I'm clear,
fellow counsel.
you were appointed on the matter that he bench wanted on.
On one of them. I think there were 2 cases set for exam and I was on one. The public defender was on the other. And then.
Okay, right. Okay, so on 1294, that was the one he bench wanted on.
Yes.
You were appointed.
Yes.
And you're also just now appointed on 2223.
Yes, Your Honor. Mr. Bernstein was.
Right. You're off. Okay. And so you want those 2 set, and is it on 2223 that you don't have the discovery?
That is correct.
Okay. And Ms. Gaines, on his other case, does the PD believe they have a conflict? I mean,
No, Your Honor, as I'm looking at this next piece, that we withdrew from 3 of his cases, and I think.
And 3, you withdrew from 3?
Yes, and I think this may be the one that we kept. So as I'm looking at it, I think that's where, but I did not see these case numbers on the docket. So if I could have a moment to ask Mr. Hicks if he would still like to have his preliminary exam, we can go ahead and set it because it had previously been set.
Okay. And, here's the other thing. And my next date is what? The 3rd?
Yes.
Okay, so just so you understand, his case has to come back to me. So it's not going to be set on the 20th. It's going to be set in any event on February 3rd. I think it's my next date.
So it's not me on the 20th. Do you want to adjourn PCC?
I mean, I'll set them all for that date, although the other one wasn't really before me, but to keep them all together, if that's what you guys want to do.
I don't. Either way, you're exam.
Suppose if I don't have them, I don't.
Want your data. Are you saying?
You guys might want to be.
I'm living in the ozone. I'm living in the ozone, so I'm trying to get home quick so my bed won't be in jeopardy.
Oh, are those Mackie screen sheets? Is that what they are? While we had that break. Is that what those are? Oh, okay, great. I'll sign it.
Your Honor.
Where's she going?
She's speaking to someone who's.
To who? What? Oh. Nobody else would get away with this except Miss Gaines. Just walking away. If it had been anybody else, I would have yelled.
I'm so sorry, Your Honor.
No, you don't have to apologize. What are we doing?
Your Honor, I was just confirming, Mr. Hicks was indicating to us that he is a resident at Ozone House and the Ozone staff is here present. And I was just confirming that they were here present. And we are requesting that while we are going to be making a bond argument so that he would be able to return to Ozone House and be required to follow whatever conditions that they have, as well as to come back to court. And he has drunk driving school tomorrow. Truck driving school tomorrow. Let me just say.
Get me back in jail.
This is the day that I'm going downhill, right?
She tried to get me back in jail.
No, sir. Mr. Hicks would never even being.
Hey, I don't drink, sir. I don't
Yeah.
drink.
See,
I'm
that's
not
all.
a drinker. I'm really trying to do good, sir.
Yeah, apparently you're going to school for that. So, do the people have a position on bond? I mean,
I just have concerns given the previous failure to appear in the nature of the charges rather than.
And I'll be on tether, so.
Hold on. All right.
And Your Honor, I will indicate for the newest case, I did speak to Mr. Hicks. He has no reason to be at that resident. I think he doesn't live near that residence anymore, so he would understand that he's not to go to that residence for the newest case.
Right. Okay, I get that, but why didn't you show up? I mean, the problem I have is him not showing up for the preliminary exam. I mean, because all the witnesses, everybody's here, and then he doesn't show up. How did he come back into custody?
So if I may start, Your Honor, he is indicating that at the time of the preliminary examination, he was homeless at that time. So his situation is substantially different by working with Ozone House and having a place to stay. Is that correct, sir?
Yes, and they gonna make
Okay,
sure
so I get that part, maybe.
show up to court.
So the other problem that I'm having though is how did he come back into custody? Was he picked up, would be the new case?
That is my.
Is it the new case that he came into contact with police and then that's how we got him back on the warrant?
That is my understanding.
Otherwise, we wouldn't see him.
He does indicate that he tried to contact the court, but there was, I think it was about 4 days.
He's got attorneys all over the place.
Yeah,
I mean, he had you guys.
I had a
And
Friday, sir. I broke my shoulder, dislocated my shoulder, so I was in the hospital. So I never had a chance to call him. So my plan was to call that Monday, but then fortunately, I got wrapped up in another case. So I was trying to call, man. Please just give me this. So I won't.
Well, no, see, that's my problem. My problem is you don't appear, and it's one thing, I guess, if you don't appear at a PCC, although I don't like that either, but your case is set for exam, you don't appear. Then the only way that you get back here is that you have police contact, pick up another case that they arrest you on that warrant. And so now you're held on more cases than when you didn't show up.
Yeah, I give you my word, sir, that I won't. I make sure
You gave me your word the last time. That didn't work. No, it didn't work. You
time.
didn't show up, and then you picked up a new case.
I did try to show up to court, but I just went to the wrong day because I had a lot of court dates. And now I'm
Okay, well, that's not a good thing to
They're
tell
gonna
me.
help me make sure I show up to the court. So they're gonna make sure you drive me, take me to the court. So I make sure I show up to court. And she actually here today. So
No, I know they're here and they're good people. The problem is you have to be cooperative with everybody on this.
Yes.
And you haven't been cooperative with the court.
Yeah, I'll take accountability and I apologize. As a man, I apologize.
Young man, I appreciate what you're telling me, but I don't see how in good faith I can let you go.
Please.
Thank you for the please, but I'm gonna still tell you, in good faith, I can't do that. I would consider a written motion before the court so that everything can be considered if that's what you want to do. But I can't on the facts of what I see right now do that. I mean, and young man, so that you understand, and there was a gentleman this morning, same thing. If you're out, if you're out and you're out on bond, then you don't appear for your proceedings and we don't hear from you because everybody has an attorney and your attorney's not contacted, you're not doing anything to get back. But the only way that you come back before me is you're picked up on something else. I'm not letting you back out again absent extraordinary circumstance. Okay?
I understand.
So This one has to be set before me. My next date is the 3rd.
Yeah.
And because the preliminary examination that was originally set was before me, preliminary examination in all of these matters will be set February 3rd, 2026, 9 a.m. All of these will be set before me. At this time, his bond will continue. If between now and then you wish to file something, you know how to get to my staff and we can try to set something if the time permits. All right. Thank you. Yeah. Right, I'm gonna be an issue.
Yeah.
Court does call the case People versus Bernard Brock.
Anna Mackey on behalf of Mr. Brock, who is approaching. Please state your name.
Oh, sure. Bernard Brock. Thank you.
Your Honor, requesting to adjourn this matter. I haven't been able to get in touch with Mr. Brock to go over the media. Is there not a green sheet?
What?
Do you have a green sheet or no?
Nope.
There'll be one
This
soon.
seems to be something consistent with you today, Miss May. I don't know. I'm not blaming you. Well, I am.
So we're requesting to adjourn this matter.
During the matter, January 29th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
You're welcome. We'll await the green sheet. Court does call the cases of the People versus John Hart. 3 cases.
Assistant Public Defender W. Lebo for Mr. Hart, who stands to my right, and we do have an agreement whereby he'll be waiving his exam.
On all of these cases?
Yes, Your Honor, if I could place the agreement on the record, please.
Go ahead.
Thank you. In the 25F55814 matter, the agreement will be that there be an offer at circuit court for a plea to count 1 with a dismissal of counts 2 and 3. In the 5854 matter, there is an agreement to a dismissal of count 1 upon a plea to count 2. And in the 1168 matter, there is an agreement to dismiss that case in its entirety upon pleas to the other 2 matters.
That's all.
And I have the waiver form.
Mr. Hart, you understand that you're waiving your right to preliminary examination in these 3 cases?
Yes, Your Honor, I do.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir, I do.
You understand you'll not have that hearing and that you'll proceed to circuit court for further proceedings?
Yes, sir, I do. I do. Yes.
For the
One other
record,
thing, I want to thank you for giving me the opportunity to do that. Because
I'm sorry?
I want to thank you for giving me the opportunity to do that because you've listened to me instead of just rushing me along. The whole time I've come in front of you, every time, you've listened to me and I appreciate that. Thank you. And I'm going to Don Farms now because of you. Transitional. You wanted to send me to Hope, Mercy, whatever, but Don Farms is local and I've been there before 5 years ago and they're great. They're great. I appreciate you.
Well, thank you, sir, for saying that. And that, I'm not sure what to say, but that means a great deal.
How about go blue? Huh?
No, that doesn't, that
Go
really
green?
can't. That's really hard for me to come out of.
I know. Thank you, though.
But I can say go Terps.
For real.
But, all right.
Have a good rest of the day. Thanks.
Well, hold on.
Not done
Got it. We still got more to do here. So,
Okay.
Preliminary examination having been waived, defendant is bound over in the case ending in 1168 on the single count. In that case, in the case ending in 4545, he's bound over on counts 1 and 2. And on the other matter, he's bound over on count 1 with counts 2 and 3 following.
And we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. Pretrial in these matters will be set
January 20th, 1:30 before Judge Comfy.
January 20th, 2026, 1:30 before Judge Comfy.
Yeah.
Bond in all of these matters will continue.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you. Thank you, sir, and
I
good luck to
appreciate
you. All right. No, I did. I don't know what I did here.
That's fine.
I know he does, but he called it first, didn't he? Court recalls case, People versus Bobby Tennyson.
Your Honor,
David I. Goldstein appearing on behalf of the defendant. Your Honor, maybe Mr. Cook and I approach briefly.
Briefly.
Not here today.
What'd you say? All right, bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety.
Thank
That
you.
warrant will issue immediately. That's called the case of the People versus Jermaine Johnson.
Assistant Public Defender Kelsey Reveals with and on behalf of Jermaine Johnson, please state your name.
Ryan Johnson. Thank you. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that he is going to be pleading guilty to the charge of attempted resisting and obstructing the 1-year offense. On his successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement. The sentencing judge waiver is not checked, but that was reviewed with him.
Oh, I'm sorry. You understand you wouldn't be sentenced in front of Judge Simpson?
Yes.
May I have him sworn?
Raise your right hand. You solemnly swear to confirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name, please.
Jermaine Johnson.
All right. Sir, it is this court's understanding that you are going to be, well, hold on a second. Yeah, there's two cases, and I'm sorry, I didn't go through the other one. In the other matter, that being the case ending in 5805, he's going to be pleading to use of cocaine. That's a count 3, and counts 1 and 2 would be dismissed. And the sentencing judge waiver would also apply to that one. You understand that, sir?
Yes, I do.
Yes, Mr. Dar. You've been sworn. Sir, I do, on the one case, court believes you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
I understand, yes.
And on the other matter that you're going to plead to the charge of use of cocaine, that's also a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that?
Yes, I do.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentencing these matters before Judge Valvo, or her successor, which we kind of know now, but I'm not sure the dockets will stay that way, but you understand that, sir?
Yes, sir.
All right. Understanding that, you still wish to plead guilty to these charges?
Yes, I do.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of use of cocaine, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I understand.
You signed or had cause to be signed an advice of rights form on your behalf. Is that correct? You have any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
I understand, yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce?
No.
You're doing this voluntarily?
Volunteer.
Of your own free will?
Sir.
And because you believe that you're guilty of this?
Yes.
Yeah. On the date, starting with the attempted resisting and obstructing on the date of November 24th, 2025, at the location of Las Vegas Drive near Palomar Drive in the city of Ypsilanti, or city of Ann Arbor, Washington County, state of Michigan. Did you come into contact with police officers from the Ann Arbor Police Department?
Yes, sir.
What happened?
I rode off on my bike.
You what?
Rode off, tried to get away.
Did they give you an order to stop?
Oh, they told me to stop.
They told you to stop. You said, I'm not stopping, and just kept going.
I was thinking about Thanksgiving.
You were thinking about what?
I was trying to make it to Thanksgiving. I promise.
What day was Thanksgiving?
Was it 24th?
Mm-hmm.
Trying to make it to.
So 3 days before you were trying to make it to Thanksgiving, where were you going?
I was trying to make it home.
Okay. No.
Get myself in.
Oh, gotcha. I see what you're saying. That didn't work out, did it?
No, it didn't.
Yeah, it didn't. Okay. And you knew that they had given you a lawful command at that point, and you disobeyed it.
Yes.
All right. The other case. These would be uniform, there wouldn't be a problem. I'm not gonna worry about it, we'll just find it in. Seriously, people. On the date of June 4th, 2025, at the Packard Road near Platte Road, city of Ann Arbor, Washington County, state of Michigan. Did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
All right. Sir, I do have to advise you that if I accept your plea, between the time that I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not, first of all, not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I understand.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty in each of these cases to count 3. Counts 1 and 2, I think the both matters, are dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
Third at 9 a.m. For Belleville.
February 3rd, 2026, 9 a.m. And it's before Judge Valvo in each of these cases. On will continue. He has I did, so that you're aware, I don't know if it was sent to you. They requested that he be released to treatment. I approved that on his cases. So he might go to treatment. That was something through the sheriff's department that they sent us.
Would Your Honor consider, in light of the plea, a personal bond today and then allowing him to, of his own volition, seek treatment?
You really want to go back through the warrants where we had to find him?
Oh, you're not gonna have to find me.
Well,
We do have his current address. We know where he would be located.
I should have just let it go. What I was trying to tell you is I've signed an order to release to treatment.
Oh, yeah, that's fine too.
And that was sent through the jail process as opposed to, and I've approved his release to treatment. If you'd like him released on a PR bond, you can take that up with Judge Pavlo's successor or whoever's handling it. I'm not going to change it at this point.
I understand.
All right.
Thank you, Your Honor.
Thank you, sir. Good luck to you.
You have to fill out his packet.
Okay.
Court does call the case of the people versus John Brown.
Andrew Phillips, right now, there are people.
Brian Bowling on behalf of Mr. Brown. State your name for the record, please.
John Brown, how you doing, Your Honor?
I'm doing okay. I may be.
Judge,
Go ahead.
for purposes of the probable cause conference, I'm asking for an adjournment so that we can review the video from the incident with Mr. Brown.
You have his violation?
I do. I'm aware of it. Mr. Brown and I have spoken about it, Your Honor.
Oops.
Okay,
Your Honor.
want to deal with that? I'll give you the adjournment.
Yeah, ultimately, Your Honor, Mr. Brown, I would advise you against saying anything.
Well, I just wanted to speak on the violation. So
I was going to speak on the violation, but you're welcome to do it if you'd like to.
honestly, Your Honor, it was on a violation. It was a misunderstanding. When I went over there to drop, and then she called me back for a phone interview. I asked her what was the next, and she said that would be up to the judge. So 3 days later, I spoke to Alexis, my old lawyer, while I was at work, and
Your Honor, may I say something on Mr. Brown's behalf with respect to the violation? Judge, he would admit to missing those tests on November 13th and December 18th. However, he did report and tested on November 3rd. He's currently on.
And was positive for THC. You got a medical marijuana card?
He does not, Judge. He indicates to me that he's on probation with Judge Slay. To my understanding, that's going very well. He did surrender himself on this matter to address this case. He does want to comply with this court's bond conditions. He wants to test as ordered.
And why didn't he go?
Well, he did go originally, Your Honor, but
I went and he's positive for a drug he cannot by court order soon.
Granted.
Then we don't see him again.
Well, like I said, he is on probation. There is an order with that court and that status to test. I do believe Mr. Brown, and we spoke last night after receiving this report, where there was a misunderstanding with his discussion with Ms. Dozier that the testing that he was doing on probation would be satisfactory for the purposes of bond. That turns out that was his understanding. That's not accurate, Judge.
Is that where the case? Why did he go on the 3rd?
Because that was the initial intake. That was the initial test. So if the court would allow him to go over to community corrections now, he could get testing established and he would continue testing. I cleared it up with Mr. Brown when I talked to him last night and today. I
still doesn't have a card. Is marijuana going to show up in your system?
It will, Judge.
a little bit will.
A little bit?
Yeah, I don't know how the levels go.
Just a little bit of weed.
Cause I don't know how the levels go on New Year's Eve. I don't drink, so I did. I did eat an edible.
Smoking what you got?
I mean, I'm not gonna lie to you.
No, I don't want you to lie to me. I'm just saying you're on bond.
Yeah, and I didn't even I was up until I spoke to him yesterday. I was unaware that it was even illegal to smoke marijuana because it's legal. So it really was a misunderstanding, Your Honor. I'm asking you not to lock me up for it. Right now, I'm working. I got a full-time job. I really can't afford to lose no days right now.
Should have gotten testing. What I'll do is I'll only set it out 1 week to the 15th. But you guys try to figure that out and maybe give me the testing that he's doing on his other matter in circuit court. But at this time, the defendant's bonds are both remanded.
Thank you, Judge.
Court does call the case People versus Sandra Law. She's coming. Law, do they have? I don't even know what file it goes in, right? Your name, ma'am?
Sandra Law.
Thank you.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Law. Say your name.
Sandra Law.
Sorry, here's a scanner for you.
Stephanie Payne on behalf of Ms. Law.
Really? Why are you late?
I know reason. I'm sorry, Your Honor.
All right.
Sorry. We're going to ask for an adjournment on this matter, Your Honor, while we negotiate in this case. I would like to address bond.
Again?
Yes, Your
Is there
Honor.
going to be anything different than I heard the last two times that I denied her bond?
Well, Your Honor, she's been in for almost 70 days now, not quite. I think it was like 67 days when I checked. and they're not releasing her to treatment. There's nothing keeping her but your case. My client absolutely does. I'm sorry, I'm a little bit out of breath.
Said that, the only, like, I'm to blame.
No, yeah, I mean, no.
Are you, no, okay, all right, okay.
Judge Washington gave.
No, Cannon, you're doing really well. Go right ahead.
No, because Judge
Like
Washington
me.
gave her a PR bond. So the only case that doesn't have a PR bond with release to the house is yours, is what I meant by that, Your Honor. Your ears turning red? Because I feel like I'm turning red. And so, Your Honor, again, my client, she does want to go to treatment. We're requesting that she goes to treatment. If you tether her to her home, she will go to outpatient treatment. We've done the process
What
here.
would change my decision from the last 2 times that you've argued this? Just give me those.
Well, Your Honor, I believe that the court wants her to be in treatment as well because this case is a drug-based case. She had been sober for a full year. She had been doing her drops, her testing in Judge Washington's, which is why Judge Washington let her go. She came back, she had COVID, she got really, really sick. And then her grandmother passed away, and she acknowledges that in that moment she made a bad decision, one that she regrets deeply, one that she regrets very, very much so. And she just was
I've
asking.
seen the movie Groundhog Day.
I have, Your Honor.
Yeah.
I really have. It's a
And
great
it's like
movie.
it just repeats and repeats and like.
My client asked me to ask you to
know.
please reconsider, Your Honor.
And I want her in treatment. I really don't want to hold her.
I understand.
But, and that's why I said, treatment, great. But do I trust and will I release her on a straight PR? At this point, I will not.
And Your Honor, thank you.
Can I speak here on her for a minute, please? I wrote you a letter and I signed up for schooling to start January 5th for psychology. And I do have a job and they'll only hold it for me till February. And I do have a house, which you know the situation, and we have a court date tomorrow with you, with the Sturman Serenity and the Thomas Berry case. And I please ask you, because Judge Washington did want me to go to treatment, and I've been in her court with her since 2023. And I promise you, I will get into intensive outpatient treatment. I promise you, you will have no dirty drops. I will drop 2-3 times a week for you. I don't want to lose my schooling, my house, my job. I've worked so hard for 2 years to get sober and work with Judge Washington. I promise you, she's put me on house arrest tether, not a GPS. So I can only go to work for my 3 months of probation. I promise you, I will do your court with flying colors if you please PR upon me to go home so I don't lose everything I worked so hard for. I wrote you a letter, Your Honor, pleading and begging you to please. I don't want to lose everything. I don't want to have a gap and go backwards in life. I've been an addict for 15 years, and it took me 2 years to get where I am today for one relapse over a death in the family that I beat myself up over. I went to my doctor. I've cried to him. He had put me on a cocaine blocker called Topamax. So if I ever came across a situation like this again, where I've had a damper in life, I would have the blocker to stop me from using. It was a one-time relapse. And like Miss Washington said, the old Sandra would have tried to beat the test, beat the system, just not dropped and missed the test. And she was proud of me that I didn't try to beat the system and took responsibility of my dirty drop. And I did. I didn't try to do anything to beat it. I didn't try to, I just, please, I beg you, you'll not have to ever put me in jail for a dirty drop again. I promise you that on everything I love. I don't want to lose what I've worked so hard for. It's been a struggle for me since 2023, working with her to get this far. And, I was already on the tether, set to go to treatment the day I had court with her. And that's what stopped me from going, because she was going to put me into a long-term treatment. But then when she realized and evaluated the case, she said, no, I'm not going to do that to you, Ms. Law, because she knows the struggle I had and how long it took me and how hard I worked to get where I was. And I can't say anything but to please give me that chance. I've never been in front of you, and I promise you, you'll never have to ever worry about me being in front of you for a dirty drop again. That's all I can say, Your Honor, please.
I'll adjourn this matter to January 22nd, 2026, 9 a.m.
Thank you, Your Honor.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Days, People versus Amaya Campbell.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Campbell, Your Honor.
Oh, there she is.
She's here.
Hi, good morning, Your Honor.
I'm doing well. Your name?
Amaya Campbell.
Thank you. You're requesting an adjournment on this.
Yes, Your Honor, there's some video we need to get a look at. I thank Mr. Childers for requesting it.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue. Thank you.
Thank you.
Court calls case of the people versus, oh, there. Versus Melvin Lilly.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Lilly, just to let you know. Mr. Lilly, will you state your name for the record?
Melvin Lilly.
Thank you. And asking for an adjournment. I did reach out to the prosecutor's office for consideration for a reduction. They're reaching out to the officers.
Probable cause conference, then January 22nd, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court calls case of the people versus Gerald Casanova.
Assistant Public Defender Chelsea Burfield on behalf of Gerald Casanova. I haven't had contact.
Haven't had. Casanova. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. Cash surety. That warrant will issue immediately. Court calls case of the people versus Chairless McLaughlin.
Anna Mackey on behalf of Mr. Chalice McLaughlin.
All right, what are we doing?
Your Honor, we're waiving. I believe there was a traditional waiver done already, but
Bring this to the 15th, 2026, 9 a.m. Bond will continue. Thank you.
thank you.
Court calls case people versus Wesley Brand.
And then on behalf of people.
Wesley Brand,
It's not in Washington County
he's
Jail.
not on yet. He's in custody, but
Yeah. It's not.
I'll pass that.
It's gonna be just a couple minutes on Brand. I'm starting to make my way down there. If you can just give me a couple.
Okay, all right. We'll wait. Turn on the camera. We'll call you back. Court does call the case people versus Donovan Smith.
Ready, our people on behalf of Donovan Smith. Donovan, would you state your name for the record? Would you just state your name for the record?
Donovan Smith. Thank you.
Judge, this is a situation we're at. I was just appointed on this case. This is his second case. His first case about a month ago, we bound over to circuit court. To Judge Kuhnke, there was an argument of what had happened. Long story short, Judge Kuhnke yesterday ordered that the case be remanded back down to district court for a preliminary exam. And
on what theory?
Well, Judge, this case and the case, the original case, both had the same offense dates, were hours apart. It was our argument that they should have been bound over. We should have known them together for what that's worth. And so long story short, I got a note from Judge Kunke's office that they were remanding the case back for the 15th. So I was going to ask for a 1-week adjournment and get these matters.
Had the other case already heard an exam?
No, we waived the exam, Judge, on the condition that the bond was lowered, which it was by you, from 50,000 to 10%. And then once we got up to circuit court, we found out about this case, which was the exact same day, only hours apart. And our argument was that we should have known about both cases.
Okay.
So all I'm asking is, Judge, if I know my client wants to have an exam in this matter, I don't have the police report, but that's fine. If he wants to set an exam, we can set an exam. But I was told by the Judge Kunke's court, the case would be set for the 15th. I don't know if that's true or not. Well, I guess what I'm asking for, Judge, is I know this is a very impatient man, set matters for a week from today.
May I speak?
Go ahead.
First, I don't know if you remember me or not, but I've been in here.
I remember everybody.
I adjourned like 6 times.
No, I remember.
And then my lawyer made a deal with the prosecutor. They'll 10% my bond and they can't add no new charges if
I remember. Well, I don't know that no new charges were part of it. I remember it was just listen.
Okay.
I'm telling you what I remember specifically about it, because it's unusual for me to even agree to it, was that you were going to waive up and I reduced your bond. All right. That I do recall.
That case was a discharge of a building, so it was our impression that they weren't going to add any firearm charges to that, any additional charges. I did not know about a second case where he was allegedly caught in a car with a gun. So now this charge is CCW. I can understand his frustration, but there are 2 different cases at the same exact day.
Your Honor.
Yeah.
I never got arrested with a gun. They never.
Sir, I don't want to talk about the facts of it. I'm just procedurally trying to figure out why in the heck we're where we are. The case waived up, right?
Correct.
I reduced his bond. Did he get out? Did you get out?
He tried. That very day they charged him. The second day he never got a chance. He was arraigned a $25,000 bond on this case, which prevented his release on the first case. He never made it out, Judge. He was about ready.
So there was an agreement that he'd waive up. I reduced the bond. They didn't charge a new case and he's held.
Correct.
That's beautiful.
So what we were asking today on this case, if it would be $25,000, 10%, I don't believe the prosecutor has an objection to that. Hopefully both matters can be heard next week in this young man.
Well, I don't even know. Here's the problem. And I don't have a problem with that, Mr. Kilowald. The problem that I have is something's coming back from circuit court. It's supposedly set for the 15th. I don't know that. And usually if something is going to be set on this docket, we get a call. If somebody tells us, because we'll give them the date. And so what I'm a little bit worried about is I'm going to adjourn this young man's case out next week, and I still don't have that other case.
I think I can't say for sure, but it sounds to me like the circuit court case, circuit court.
I don't know why that's coming back to us. I don't get that. And I'm not saying that anything you're telling me is not what you know. I don't know why it's coming back. And you're telling me there's this case coming back. He's got this case. I remember what I did when I released him on the other case. And now he's back in, and you want me to give a date that I don't know is going to be able to go for. I mean, none of this is making much sense to me.
I think this young man thought that there would be no new charges.
Well, whether or not there are new charges or not, I don't know that is necessarily my issue right now. My issue right now is I'm trying to get his case heard. And I can't, this case that's in front of me right now, I can't even get that heard because now you're telling me there's this other mythical case coming back to, I don't know. And it's on the same day. Do we have anything?
Listen to me. 1 week. No. You don't understand what I'm saying.
No. Here's the thing. If I adjourn it out, well, you guys have your conversation. I'll just wait.
Judge, I'm sorry. I understand his frustration, but I don't have.
Well, yeah, I understand his frustration too, because he waived up. I reduced his bond, new charges come. He then gets a new, he then can't go. And then when the case goes up, regardless of what his understanding was and what that was, now all of a sudden it's going to come back. Meanwhile, while all that's happening, I'm in custody. So, gee, I don't know why he's frustrated. Because as you can tell, I'm not. Okay, but here's what I'm going to do, okay? You may not like the answer that I get, but at least what I'm going to do is I'm going to get an answer so we know what to do, okay? Because I don't want to set it for next week, and next thing I know, that case coming from circuit is 2 weeks out, because then I got to bring him back again. That doesn't even make any sense to me. So say nothing.
Judge,
say nothing.
As far as bond,
say nothing.
You're very considerate, Judge. Judge, I think. Would you?
What?
What's the probable cause for this case?
Fine.
Please ask that.
Here's what I'm gonna do. I'm gonna pass the matter, take him back. We're gonna call, I'm gonna call down, or my staff call down. We're gonna figure out where this man's case is at, where everything is, and try to get it all where it's supposed to be.
All right, thank you.
And nobody may like the decision I make in the end, but at least we'll know what's happening, because right now we don't even know what's happening. You understand me?
Yeah.
Say nothing. Take him back. Court calls the case, People versus Donovan Smith. No, that was the same case. Why are you doing it? You know what the Lebo look is?
Pardon?
You know what the Lebo look is?
The what look?
Lebo look.
No.
Lebo gets up here all the time. I call the case. He doesn't know if his client's here, but he looks through the door expecting some miracle. So I expect that's what you're doing.
How did I get involved?
You're the cause of it.
I tried to get a hold of Mr. Copeland. His phone number was invalid and his email was also invalid. We're respectfully requesting to adjourn this matter so I could attempt to get a hold of him.
Bench warrant will issue bond 10,000, cash surety. That warrant will issue immediately.
Thank you.
Court calls the case, People versus Latricia Mopkin.
Hannah Mackey on behalf of Mrs. Mopkin, who's approaching.
No, look this way, man. Come on up. Your name?
Latricia Mopkin.
Thank you.
Your Honor, requesting to set this matter for preliminary examination. And all discovery is complete as far as we are aware.
Will the people have their witnesses available the 20th? Preliminary examination in person will be set January 20th, 2026, 9 a.m. before Judge Fresh Hour.
May I address bond, Your Honor?
You may.
Ms. Latricia, she works at U of M as a housekeeper. Currently, she's on non-paid leave. However, that's temporary and she could permanently lose her job there. She has 4 kids and one of them Miss Latricia is the sole provider for her kids. Her family is here today in court as well, and she has a place to stay with them upon release. So we're asking for Miss Latricia to be released, and she is okay with complying with GPS tether or any other conditions the court finds necessary.
Response.
Your Honor, at this point, I'm going to object. This is an extremely serious case in which the victim was attacked with a hammer in which she was hit in the head several times with that hammer. There was a struggle then for that hammer, and during that struggle, he was then stabbed in his stomach. So given the severity of this case and the injuries that she sustained, I'm going to object at this time. Any modification of bond.
And Your Honor, we are presenting this case as a self-defense, and Miss Latricia would not be staying at that address upon release. She would be staying with her daughters, looking after her.
I mean, typically the self-defense isn't, I mean, are you indicating that the alleged victim possessed some weapon at some point?
I believe there was some form of altercation.
Well, an altercation is one thing. Are you saying that a weapon was possessed? Because that might factor into the court's decision, but if that's not what's being said, then I'm not sure that true self-defense is going to apply in any event, although I'm not trying to make that analysis.
There was no actual weapon.
Do this. There's the allegation that there are two weapons that would be used by this defendant.
He did have a knife, Your Honor.
Okay, then you can certainly address that even, while I'll factor that in, I still don't think bond would be appropriate or a reduction in bond would be appropriate in this case. I'm going to deny your request. Certainly you may raise that after the preliminary examination on the 20th before Judge Freshow.
Thank you, Your Honor.
Thank you.
This different is in Zoom. I have an answer on the other one.
I'm not jumping.
Looks good.
Guys want to walk around?
Young lady, no, come here. Come here. Oh, boy. Get her, Mr. Allen. Who is that? Who was that?
Family of the last client, I believe, Your Honor. To the full moon.
What?
To the full moon.
No, people are usually better. They're not back yet. That means there's a problem. You got a problem probably in the hallway, guys. I'm sure security sees it. Can you just call and make sure that they're How many more do I have?
So, custody in custody. 2, 5, 6, 7. And you got that over there.
Be careful.
I want to look. Oh.
Should have given bond.
Yes, I'm so sorry. Yes, so that matter has come back. Apparently, I looked up at GIS, but yesterday, the company's office called. They don't show. It's on next week. Go.
Just step off. If she brings them in, just throw her in the box over here or cover, put her wherever. Lady, what's your name?
Sequoia Jones.
What?
Sequoia Jones.
Why were you causing a disruption in the court and then
I
didn't
was
come
talking
back?
to my mom's lawyer and he stood up. I wasn't talking to him. I didn't say nothing to him. I was talking.
Why didn't you then stop when I told you to stop?
I apologize.
That doesn't work that way.
Your Honor,
You want to be represented by counsel, ma'am, because you disrupted these entire proceedings. You want an attorney?
Yeah.
The PD can handle this, I think. She can go back into custody. I'm going to take a brief recess and then I'll bring her back out. We'll deal with it.
All right.
Assistant Public Defender Davy Leva on behalf of Mr. Covington. Please state your name, continue some discussion as well as get some additional information. And you're going to be requesting an adjournment today in order to continue some discussion as well as get some additional information.
Probable cause conference, I'll set it for January 29, 2026, 9 a.m. Or as your invite indicates.
Thank you.
And will continue. Thank you, sir. He's adjourned. Court does call the case, People versus Dontrell Smith.
Dontrell Smith.
Your Honor, Mr. Pillwall had to go back to his office real quick so he can cut that.
This is not Mr. Pillwall.
Oh, I'm sorry.
I'm ready to go. Mr. Smith is in custody.
Pardon? I don't have it.
Brian Bowling on behalf of Mr. Smith, he's in
Are
custody.
they not respond? Yeah. He's,
They're not responding.
they don't have some,
Dontrell Smith is in Zoom. They have turned off their.
I know, but now the camera's on.
You ready for Smith, Your Honor?
Yes, sir. Yes, sir.
All right, we'll get him.
Hey, Smith, come on. You ready?
Guys, call the case of People versus Dontrell Smith.
Brian Bowling on behalf of Mr. Smith. Mr. Smith, can you state your name, please, sir?
Can you tell us your name, Mr. Smith?
Dontrell Smith.
All right, thank you.
I'm asking for an exam, Judge. I believe all discovery to be complete.
People have their witnesses available the 20th. Preliminary examination will be set in person, January 20th. Is that right?
Yes.
2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Brandon Myers.
Glenn appearing on behalf of Mr. Myers. Can you please state your name for the record?
Brandon Myers.
Thank you, sir. All right, what are we doing?
We would like to request an adjournment, and when appropriate, I'd like to address bond.
Do I have a green sheet? No.
Oh, yes. Fabulous.
Probable cause conference in these matters will be adjourned to January 22nd, 2025, 9 a.m. All right. Yes.
Okay. Your Honor, we are requesting that Mr. Myers be released on a PR bond with a tether to his grandmother's house.
No.
I'm sorry, to his mother's
My
house.
mother's in the courtroom too.
She has a lot of health needs, and she has,
Is this the same motion that I already denied?
We've never done a motion.
Oh, yes, you did. There's a motion on this, a motion to modify his bond, which I denied on December 11th. But go ahead.
Is that a no? She's in the courtroom?
Yeah. He wants me to let you know again that his mother is present today. She has a lot of health issues, including her vision is severely impaired. And Mr. Myers is her support system. He takes care of the house. He helps his mother get to and from her medical appointments. He has a strong tie to the community. He has a positive support system, which includes 3 of his family members are here today. And
I went to school with her.
he also states that you went to school with his mother as well.
Pardon?
You went to school with my mother.
I did?
You seen me in 2008 and you said you did know my mother. She's right there, the light skinned lady.
The light skinned lady? Really? Which one do you want me to pick out?
The one that's laughing right there.
Okay.
Her right there.
Hello. Okay.
Okay. Your Honor, we believe tethering him to the house would keep him from interacting with the complaining witness. And he is well aware of the PPO and in this court's direction to have no contact with the complaining witness.
You know I don't play with him either. I don't play with you either. You know that.
What?
I don't give you no hard time either. I do what you do.
People can give me a hard time. When you go back, you can ask that young lady. Is there a response from the people?
Your Honor, since this motion was already brought about a month ago, we asked the court to deny it and just highlight the facts where the defendant is reported to have come to the victim's house, threatening to kill someone if he sees. Also showing up at the victim's church, creating a where he also.
That's a lie.
That safety of the public is necessary. And that bond should be continued.
I ain't threatening nobody.
All right. I've already heard the motion and ruled. I don't hear anything different. If maybe there's a conversation had with the prosecutor and there are certain conditions that will alleviate their concerns, and then maybe the parties can stipulate to something, but I'm not at this point going to change the bond or the court's decision. The motion for bond reduction is denied.
Thank you, Your Honor.
Court calls the cases of the People versus Bernard Lee Fonville.
Okay, well, I'll keep it.
5, 6 cases.
Mr. Bonville, will you state your name for the record?
No, we found him.
Thank you.
Thank you.
Your Honor, we're asking for an adjournment to review discovery with Mr. Fonville.
Is it extensive or is it?
No, there's just 6 files to review, so.
Yeah,
just
that's what.
A couple weeks. I provided him a copy of the discovery today, so.
Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you.
Good night. Take care.
Court calls case People versus Johnny Charles Payne.
Michael Gaddy, Assistant Public Defender. Payne is approaching your.
Your name, sir?
Johnny Payne, sorry.
Thank you.
Yes, Your Honor, I've had a chance to speak with Mr. Payne and with Mr. Cook. Your Honor, I'd ask Mr. Payne has a parole hold I need to investigate. We were going to set this date for exam, but I'd ask the court to adjourn it so that I can continue trying to reach his parole officer.
The 22nd or 29th?
The 29th would be good, Judge.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue.
Thank you.
Court calls the case of the people versus Carlton Cross.
Thank you.
Assistant Public Defender Davi Leba on behalf of Mr. Cross.
Hello. Hello, what's your name?
My name is Carlton Dion Cross.
Thank you. You're
Thank you,
asking for
sir.
an adjournment for additional discussion.
I am, Your Honor. Thank you.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, sir.
Thank you, Judge. Thank you.
Calls the case, people versus Adam Perella.
Assistant Public Defender Davi Leba on behalf of Mr. Perala. Could you state your name?
Adam David Perella.
Thank you.
And Your Honor, we would like to set this matter for preliminary examination, please.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 20th. Preliminary examination in person, January 20th, 2026. Sorry. 9 a.m. It's going to take me a minute before Judge Freshour.
Thank you, Your Honor.
Bond continue. Thank you. Court calls case of people versus Zakara Daphne Bursiaga.
I expected this to be called when you took that pause, Judge. So,
Yeah.
Brian Bowling on behalf of Ms. Daphne Bursiaga, Your Honor, can you state your name for the record?
Zakara Daphne Bursiaga.
Exactly what I said. I'm pretty proud of me. Go ahead.
Your Honor, we're asking for an adjournment for ongoing plea discussions in this matter.
Okay. What? Councilor. No, this is. Let's do February 5th, 2026, 9 a.m.
Thank you, Your Honor.
You're welcome. Bond continue. Court calls case of the people versus Jack Saunders.
And we have the people.
Stephanie Cannon on behalf of Mr. Saunders, who's approaching. Mr. Saunders, could you please state your name for the record?
Jack Lee Saunders.
Your Honor, we are asking for a 2-week adjournment in this case for plea negotiation purposes.
Without objection, January 22nd, 2026, 9 a.m. Bond continue.
And Your Honor, there is a violation.
Is there?
It's my understanding. Yes, basically, yes. And there's, well, it says a lot of stuff.
Here's a bond violation, no bond.
Yes, Your Honor. So we are going to ask for a hearing as to the violation. My client had double pneumonia, and so for a chunk of this, he was just in the hospital. And so we got to
Have proof of that?
we're getting release of information for University of Michigan and for Trinity. So when I
For the
spoke with
22nd at 3 PM.
122, Your
And
Honor.
I'll set a hearing on bond violations at that same time.
Thank you, Your Honor. Perfect.
At this point, his bond will continue. Thank you.
Our cause case, people versus Juwan Daniels.
And Maggie, on behalf of Mr. Daniels,
Your name, sir?
Juwan Daniels.
Thank you.
Your Honor, requesting to adjourn this matter.
What is it with you and the green sheets? What is the issue? You know the routine.
It's been a while, I think. It's been a whole year since I last seen you.
No, that was last year. That was not a whole year. That was good though. She was. Probable cause conference will be adjourned January 29th, 2026, 9 AM. Bond continuing.
Thank you, Your Honor.
Thank you. For cause cases of the people versus Kirby Snyder.
Veronica Glenn on behalf of Ms. Snyder. Can you please state your name for the record?
Toby
please?
Snyder.
Your Honor, we would like to request a 1-week adjournment.
Why 1 week?
We need time to get discovery.
Is there anything else holding her? Because I'd give her 2 weeks, but 1 week is really for emerging circumstances. Nothing else is holding. We don't know why you asked for 1 week. Cannon sent you up here to say, do 1 week because you know that'll irritate him.
We need discovery. That's all I have.
That's all you have?
All I
They
have.
just sent you out there, threw you to the wolves. They need to treat you better. I'll adjourn it 1 week because you asked. There might be a reason. Oh, no. January 15th, 2026, 9 AM. And because you at least have your green sheet, Ms. Mackey.
Thank you.
I don't even know what cases, if she do it.
One's right before this one.
Yeah, I know, but I don't even know if we have the file. Court does call the case, people versus David Davenport.
Good morning, Your Honor. Randy Cook with the people.
Glenn on behalf of Mr. Davenport, can you please state your name for the record, please?
David Davenport. Thank you.
Your Honor, we would like to set this for a preliminary exam.
All right, discovery is complete.
Yes.
Oh,
Your Honor, I don't believe discovery, since we had discussed earlier, originally we're going to set for exam, but I thought we discussed a second time, we were going to adjourn for that discovery. Is that
Yes. Your Honor, Stephanie Cannon on behalf of Mr.
so
Davenport.
you didn't give the information to Ms. Glenn?
I
Is that no?
I did
That's
not,
a
Your
yes or no response. Don't
I-
worry, you're not in trouble.
That is correct. Your
What?
Honor.
That's a yes or no, right?
Yes, it is.
You did not give the information to Ms. Glenn, and so she took the instructions that she had them,
Yes,
correct?
that is correct.
Okay, now that we know that you have fallen down on the job and that there is needing to be an adjournment, you can sit down.
Yes, no.
No,
still
I
can't
don't need
sit
to hear
down.
from you. Sit down.
Still can't.
Sit down. I don't need to hear from you. I'm only going to hear from Ms. Glenn. Don't try to whisper in her ear what to do. I'm gonna adjourn your case out till they get all the discovery.
Okay, Your Honor, we would like to request an adjournment. We also would like to make a request to allow him to return home.
Probable cause conference will be adjourned. Well, where's home?
Where's home today?
Ann Arbor,
Ann Arbor?
3310 Fernwood Ave.
Oh, he wants to return to his home address.
Yes.
It's not like, you made it sound like he lived in another state. I'm like, what state is he? Where is he? Okay.
And Your Honor, people were confirming the victim that they are no longer living there, so I would have no objection to allowing him to return home and lifting the no-go too.
Motion for modification of bond in terms of the no-go to. Granted, because of Ms. Glenn's wonderful argument that was made.
Thank you.
So you may return, the no-go to will be lifted on that. And I will adjourn, given that, I'll adjourn this matter out January 29th, 2026, 9 a.m. or as your invite indicates, bond will continue. Thank you, sir.
Thank you, Your Honor.
And thank you for your patience with Ms. Cannon. Court calls the case, People versus Alicia Wittenberg.
Assistant Public Defender Jay Bellinger on behalf of Ms. Wittenberg, who approaches, Your Honor. Can you state your name for the record, please?
Alicia Wittenberg.
And Your Honor, 28 days ago, I submitted a 14B recovery court referral.
Yeah.
I have only today, after emailing them 7 or 8 times, have I heard back from them. So unfortunately, she hasn't even been processed yet. When I spoke with Mr. Reyes from that court, he advised that he didn't even know that she was in custody. So that as well as the fact that you submitted, you signed an order for her release to treatment. I've tried to be in contact with Sarah Stewart, who is handling her case. I submitted that on day 1 as well when she went into custody. Sarah Stewart still hasn't gotten back to me. It's been 7 or 8 times that I've contacted her. Ms. Wittenberg has been in for the last 28 days. As I stated, she was in on a bond violation. Your Honor, at this point, I do need to adjourn her case for the processing of the 14B recovery court referral. However, I am going to again renew my request for her release. She is working in intensive outpatient therapy with U of M. She has submitted that to the court prior as evidence. I want her to be able to be processed in one way, shape, or form as soon as possible through no fault of her own, as she's just sat in jail.
Yeah, I know. And my concern is I realize there are delays trying to get people into treatment. There are 2 avenues here where something should have happened and nothing has.
Yes.
That concern. And I would prefer, quite frankly, if there's going to be a process where she can get into a recovery court, that's going to be the best shot for her, right?
Certainly.
So
Mr. Reyes did advise, because he didn't know that she was out of custody, that he could, if she were to get out of custody, he could give her a call and set up an appointment by Friday.
In custody?
If she's in custody, he said he would need to set up an appointment with her that they still haven't unfortunately done.
We're going to turn her out to the 22nd, 2026 at 9. At this point, I'm going to continue her bond. I will consider something different if she's not, if we're in the same boat on the 22nd. I will certainly look at some way to do this differently so that she can get assessed. She's just waiting. I don't think she should have to. I get if there's not placement. I get if decisions aren't made, but at least it's a preliminary part of assessing it. we need to be able to get that done.
Yeah, I know that she stands to lose a lot, including her job, Your Honor, and I know that she wanted to speak to that aspect of it. I don't know. I know you've already made your ruling, Your Honor, but
what do you want to tell me, Liam?
The only thing I was going to say is I do have good private insurance, and that's, I have called myself and was told that I could get in under my own private insurance, but unfortunately, because I'm in here, I can't. If I was out, I'm just feeling like it could be faster than
Here's
waiting.
what I'll do. I'm going to set it for the 15th. Somebody needs to do that. Mr. Berger, if what she's indicating, get me some information that says that she can't do it while she's in custody, and then I'll reconsider everything, but I'll just put it out 1 week for him to get that. We'll take a look at it. Fair enough?
Yes, thank you.
You're welcome. Thank you. Court calls case People versus David DeLucia.
Assistant Public Defender Chelsea Regiles with and on behalf of David DeLucia. Please state your name.
David Mark DeLucia.
Right, I've been close.
Your Honor, he will waive his right to a preliminary exam.
Is that correct, sir?
Yes.
You understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing, you'll proceed to you'll proceed to circuit court for further resolution.
I understand, yes.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial will be set for
30 before Judge Conlon.
March 4th, 2026, 1:30 before Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. Does call the case, People versus Antonio Williams.
Good morning, Your Honor.